I beg to mention item number 54 of today's supplementary list.
Yes.
My lord, on 22nd of November, my lord, an order has been passed to whereby directed the petitioner to file an representation before the district commissioner. Accordingly, he has filed the representation on 25th of this month, and on yesterday, I have filed an additional affidavit to bring on record this the receipt copy, my lord. So I may be permitted to send a requisition to bring the additional. Obliged.
Item number 61, that part heard matter whether GST is to be borne by the PWD or the contractor. I have got some telephonic instruction which will favor the petitioner, but I have sought for a written instruction. It can be sorted out, madam. Only thing, madam, he'll have to approach the authority. They have been, madam, sorting out this issue, madam, of other contractors. Any day convenient, madam, only on written instruction will do, madam.
Sixth. If it's not inconvenient, sixth. Convenient. Lordship, then thereafter the week. Because second and fifth is the holiday.
Second, no, yeah, no.
Oh, sorry, fifth only. Rest ticket. Or on ninth month. Ninth. Deeply obliged.
Yeah, please, your lordship. Lordship, I'm praying for listing of 2 matters for withdrawal on the day after tomorrow. Withdrawal.
Day after
My lord.
tomorrow.
Tomorrow.
Much obliged.
May it please your lordship. Lordship, in item number 38, we have filed an affidavit and an IA. Lordship, the records may be called for your lordship. Obliged.
May I please your lordship? Lordship, I beg to mention item number 24. Lordship, this matter may be taken up any day next week.
For the request for the petitioner.
Yes, lordship, on behalf of Mr. J.M.A. Chaudhary.
24 is the request of council.
Much obliged.
My lord, I beg to mention about listing of the case, my lord. In revenue, but we are respondents. Some new persons is implicated. One to implicate that was rejected. That is why this file, it is requisition is filed. Maybe it may hard. December, the case was fixed. Whether they will be implement is rejection of implement is justified or not, that is true. Main thing is there in revenue book, my lord. And December 10 is there is a date, my lord. So
This
one date, my lord.
11.
11 is
11.
May it please, lordship, I beg to mention item number 52. That a kindly matter may be fixed on 6th of December.
Right.
My senior is on leave.
On 6. 11. I beg to mention item number 44. With the consent of other side, I would like to pray for adjournment for 44. 44. Who's for the other side?
I'm for the other side, lord.
44.
Please, Lordship, I beg to mention item number 23. Lordship, there are some defects in the petition. We may be allowed to withdraw the petition with a liberty to file petition.
Withdraw.
To file.
Item 23 at the request of
May I please, your lordship. Your lordship, item number 32 of the daily list. There is an IA for improvement. My senior Mr. Ekeda's name is there. So,
item 32.
yes,
32.
32. WPC number 6622.
Okay, before any other.
May I please? In item number 30, your lordship, orders matter. I may allow to withdraw, your lordship, as per instruction of my Kelani, your lordship.
Item 30 is an IA as well as
Yes, lordship.
both.
Matter become infected.
Item 30 is
one time look.
both IA.
I'm so obliged.
May
Please, your lordship. My lord, item 21. My lord, today I have some personal inconvenience, my lord. Can it be taken up on Friday, my lord?
Next week.
Next week. Oblige, your lordship.
Lordship, please. Appointment of an arbitrator.
Yes.
Yes.
Okay. Oh, you're appearing. Twenty.
Yes, lordship.
Wrong.
Well, I'll take my instruction.
Sir,
Yes, sir, my lord. For all the respondents.
What we took.
Yes, sir.
Stop.
Oblige, your lordship.
Oblige.
May please, Lordship. Lordship, in this matter, violation of order dated 22/5/2024, my lord.
Page number.
That is page number 7, my lord. Connected on
05.
Lordship, here in this matter, Lordship, we have filed our affidavit on 22nd of November, Lordship. It has not come on record, but the PM report is there, Lordship. So,
Have you
Lordship,
received the copy?
Yes, yes, I have. Your lordship can close this matter saying we can obtain a certified copy from the court itself. Lord. Otherwise, they have served a copy to me.
Five. I not
on 22nd 11/2024, for respondent number 5, Lordship.
2024.
Yes, sir.
I guess five. To the theory. Postmortem. After receipt of father. Petitioner one.
Petitioner one husband, petitioner two.
Daughter, father. Counsel for the respondent. Knowledge of the same. Affidavit. Post.
Petitioner, my lord.
It's the prayer made. In answer. Not. Flow. Not prayer.
Your lordship can also so that I can take a certified copy of the affidavit from the registry.
Petitioner is entitled to take certified copy. If believe that, right? You have to take certified copy of the affidavit.
Affidavit, my lord. Yes. My lord, only one thing, your lordship has recorded, my lord, that the counsel for the respondent had acknowledged this petitioner. Counsel for the respondent has acknowledged the copy of that.
It should be
If you
highly obliged, Lordship.
May it please, your lordship. My lord, the petitioner before your lordship is in a possession of a Sarkari land, my lord, that wasteland, for about 50 years back. Now, my lord, I have filed representation that I have landless people. So I may be settled with the land. So that petition is pending, my lord. My lord, here, my prayer before your lordship that my representation may be disposed of
When was it filed?
by the authority.
When was it filed?
I am filed, my lord, on 2/8/2024, Annexure 2, last one, my lord.
Yes.
Lordship needs to file before Deputy Commissioner, Lordship, file before the settlement official, Lordship.
It's up to them to decide. Whatever orders are required to be passed.
My lord.
Eight.
Five.
Settlement of
Dhubri and Kokrajat.
Dhubri and Kokrajat. Headquarter at Dhubri.
with the settlement of
Respondent number 5, my lord.
no, but who is the officer?
I could not follow, my lord.
Is he the rank of an circle officer, ADC, AC?
No, my lord, he is settlement officer. His rank is settlement officer.
Settlement officer, that's what, 5. Within a period of 30 days from the date of served by any order that is passed. Copy them and served. In the event any order has already been passed, they are served. The above provision. That's all.
My lord, I am in possession of the land for 40 years, my lord. Some protection, my lord. Till disposal of the petition. Because, my lord, as per new policy.
Any claim.
For 40 years, my lord.
Respect of the hair. And it's claimed by the state would be cited by the settlement while passing in the directive. That's all. We can't pass a vague order like that.
My lord.
If you want a shorter time, we'll give you shorter time, 15 days time. Disposal of
Only problem is this, my lord, that in the meantime, before we filed the representation. Representation is a legal representation,
There
my
is no
lord.
material here.
Lordship.
If you want instructions to be sought for, we will direct. That's
Yeah.
all. But in the absence of any specifics, we can't.
My lord.
You are saying that she is entitled to 3 bighas of land, 2 bighas of land.
My lord,
What is the
as per new land policy, my lord, 2019,
Ah.
2019 policy, my lord, at least a landless person is entitled to half bigha,
you go and apply for all that, but
Well-
that particular plot of land
my lord.
has to be allotted to you.
No, my lord. Thing is this, my lord, that may not be allotted to me.
Right.
I am a landless person. They will settle somewhere else, my lord.
Right? While
But
disposing of the
only
representation.
thing is this, my lord, interim protection till disposal of the representation.
Land development board towards land based. Defined by the government. Hence the- If you want 15 days, we'll give you 15 days. We have given the date of 30 days to be disposed of. 30 days is good.
30 days will do, my lord. 30 days will do, my lord. And my lord, regarding this division bench judgment also, that a person who is landless, occupying government land, before evicting, a notice is necessary.
Your prayer is for a disposal of
My
the
lord.
representative.
My lord,
That is what we have
that is
ordered.
that. Only thing is this, my lord, till disposal, I may be protected.
That cannot be done.
My lord.
How can it be done like that? Blanket
Obli-
order.
Oblige, your lord. Oblige. your lord. Here in this case, my lord, your lordship will turn to page 65. And on last occasion, my lord, the case was for instruction from the
Lordship,
SP.
Mr. J. Pine is collection court number 4.
$65.
Yes, my lord, page 65.
That-
Page 67, my lord, last part, one paragraph.
So the opinion was set aside.
Opinion of satisfactory.
Then
So, my lord, thereafter, my lord,
Hmm.
it was directed to the SP. The SP will do the needful. It was the order of 5/12/2019. 5 years have passed, my lord, more than 5 years. They did not take any steps. Only thing is this, my lord, sometimes police will go and ask me to come to the police station, or this. Nothing has been done properly as per High Court order. Either a reference is to be filed, fresh reference. Otherwise, police has no right to disturb us.
yes,
Lordship, Mr. J. Pine is lax on court number 4. Item number 5.
at 2 p.m.
My lord.
Ask him to come at 2 p.m. Yeah.
On the last occasion, Lordship asked me to produce the judgment of Delhi High Court, my lord. The facts are like this, my lord. Yes, here my petitioner is a purchaser, my lord. Seller has caused some default in filing the return, my lord. Because of fault of the seller, my lord, purchaser has been now asked to reverse the input tax credit, my lord, under section 16, subsection 2C, my lord. Our division bench has passed the order that your lordship will find it page 64, my lord. Start from page 56. Page 64, lordship may come, my lord. Here, my lord, the virus of section 16, subsection 2C and 2D was put to challenge, my lord. And relying upon the Delhi High Court judgment, my lord, our honorable division bench has allowed its citizens, my lord, with a liberty, my lord, to the department, that they can proceed with the person against whom the transactions are not bona fide, my lord. The judgment of the Delhi High Court was Lordship will find it page 1, my lord. I have annexed the judgment.
Delhi High Court judgment also SLP was preferred.
Preferred, it was, my lord.
Dismissed.
Dismissed. SLP order, Lordship will find it page 69, my lord.
Let us see what is the finding of the High Court's division bench of this court.
My lord. The Lordship, the findings, Lordship may kindly come from page 65 onwards, my lord, last paragraph.
Sixty?
65, my lord.
Yes.
From last paragraph, my lord, the findings are there, my lord.
Yes. Okay. So liberty is granted to pursue those matters which are not bona fide.
My lord, in my present case, my lord, in the so-called notice, there is no allegation of, my lord, fraud. Neither there is a finding of, my lord, fraud in the order also, my lord. And on the last date, my lord, my senior, Lion senior has relied upon judgment, my lord, of the another case, my lord.
No,
that
what is the situation after this judgment? The judgment has merely said that you proceed in those cases which are not bona fide.
Yes, my lord. And
So how will the department know that it is bona fide or not unless they issue a show cause? You have to reply.
in the so-called, my lord, the so-called was issued to me only on the point that the transaction not reflecting in the portal. There is no allegation that there is a connivance, there is a, my lord.
The transactions are all transactions which are not reflected will be taken to be not bona fide. Show cause is given to you. You respond.
I have responded, my lord. I have said, my lord, that there is a press release issued by the government of India saying that in the event, there is a default on the part of the seller. First, they have to approach the seller.
So what order was passed?
My lord.
By the authority?
My lord, the lordship will find it page, my lord, 59 is the observation, my lord.
$59.
50, lordship, sorry, lordship, not 59. I'm sorry, my lord. It is page 35, my lord. Last paragraph, my lord, 4.2. I find the crux of the allegation the impute so-called notice dated 33/2023 is that the notices submitted invoices, but it is not certified by supplier in terms of circular number so and so, so and so, so and so. As such, is liable to be paid along with applicable interest. Now, my
So
lord,
how will the authority find whether it is bona fide? What is the mechanism?
well, I have given the details from whom I have purchased the goods, my lord. Now it is section 76 of the act empowers them, my lord, that they can catch the seller who has collected tax not deposited, my lord. Now, even, my lord, this particular finding, my lord, the lordship will see there was no so-called with regard to this finding also, my lord. And the circular which they have relied upon, my lord, it does not require, my lord, to certification of, my lord, invoices, my lord. That I have annexed, my lord. The circular lordship will find it page 37, my lord. Lordship may kindly come to page 44 also, my lord.
Where is that circular?
Circular, Lordship will find it page 37, my lord. Here the mechanism is given at page 39, my lord.
Please read.
My lord, page 39, paragraph 4, my lord. The proper officer shall first seek the details from the registered persons regarding all the invoices on which ITC has been availed by the registered person in form GSTR 3B, but which are not reflecting in form GSTR 2A. He shall then ascertain fulfillment of the following conditions of section 16 of CGST Act in respect of the input tax credit availed on such invoices by the said registered person. 1. That he is in possession of a tax invoice or debit note issued by the supplier or such other tax paying document. 2. That he has received the goods or services or both. 3. That he has made payment for the amount towards the value of supply along with tax payable thereon to supplier. Besides, the proper official shall also check whether any reversal of input tax is required to be made in accordance with section 17 or 18 of the CGST Act, and also whether the said input tax credit has been availed within the time specified under subsection 4 of section 16 of CGST Act. In order to verify condition of clause C of subsection 2 of section 16 of CGST Act, a tax on said supply has been paid by supplier. The following action may be taken by the proper officer. In case where difference between ITC and claimed in form GSTR 3B and the available in GSTR form 2A of the registered person in respect of supplier for the said financial year exceeds rupees 5 lakhs, the proper officer shall ask the registered person to produce a certificate from the concerned supplier, from the chartered accountant or the cost accountant, verifying that supplies in respect of said invoices of supplier have actually been made by the supplier to the said registered person. The tax on such supplies has been paid by the said supplier in his return in form GSTR 3B. Certificate issued by CA or CMA shall contain UDN number. UDN number of certificate issued by CA can be verified from the ICSE website. Now 4.1.2. In cases where difference between the ITC claimed in form GSTR 3B and available in form GSTR 2A of the registered person in respect of supplier for said financial is up to 5 lakhs, the proper officer shall ask the claimant to produce a certificate from the concerned supplier to the effect that supplies actually have been made by him, the said registered person, and the tax on said supplies has been paid by the said supplier in his return in form 3B. Now, my lord, this procedure has not been followed. They never asked us to produce any certificate or anything like this, my lord. Propose says there is a difference. We submitted reply. Now finding is with regard to circular, but no notice was issued to the petitioner with regard to circular, my lord. The circular say proper officer is to ask me, then I will submit, my lord. And then lordship may kindly come to my lord page 42, my lord. It is a press release, my lord. Paragraph 4, my lord. May I read, my lord? It is clarified that the furnishing of outward details in form GSTR 1 by the corresponding supplier and the facility to view the same in form GSTR 2A by the recipient is in the nature of taxpayer facilitation and does not impact the ability of the taxpayer to avail ITC on self-assessment basis. Now, it says, my lord, even if the figures are not reflected in the portal, my lord, one can avail ITC, my lord. And then lordship may kindly come to page 44, my lord. Another press release, my lord. Paragraph 4, my lord. No automatic reversal of credit, my lord. There shall not be any automatic reversal of input tax credit from buyer or non-payment of tax by supplier. In case of default in payment of tax by the seller, the recovery shall be made from the seller. However, reversal of credit from the buyer shall also be an option available with the revenue authorities to address exceptional situations like missing dealer, closure of business by supplier, or supplier not having adequate assets.
So it is not entirely
Well, even if first they have to my lord, case the seller. If they found it not recoverable, then at best they can come for the buyer after buyer, my lord.
yes. Yeah.
Lordship, page 24.
Yes.
The part of Lordship last paragraph, it is a part of demand cum so cause notice. whereas it appears that the noticee has wrongfully availed and utilized ITC amounting to rupees 16,83,352 so and so in violation of section 16(2) of CGST Act. Section 16(2) of CGST Act releases under. Then section has been quoted. Then Lordship, whereas it appears that the instant case, the taxpayer avail and utilize ITC amounting to rupees 16,83,000 so and so as notice from GSTR 9 written for the financial year 17-18.
You come to the finding,
Lordship.
page 35,
Yes, Lordship.
4.21.
Lordship, before that, Lordship, reply of the notice may kindly be forwarded.
Okay.
Page 35.
35.
Lordship, 2.1.
Huh.
The notice filed letter dated 19/4/2023 submitted the following in support of their defense. 1. They have accepted observation of scrutiny and stated that the matter was to all, and the person who looked after GST related work was not in their contact for a long time. That it is found that the mistake has been committed at the time of calculation of difference between outputs dealer in GSTR 1 and output paid through GSTR 3B. The difference of total liabilities amounting to rupees 60,000 so and so. It is due to sale invoice of Susila Enterprise issued in month of July 2017 and are being counted twice by the system at the time of so and so. Then 2. Due to miscalculation in taxable value supply of 5% goods and 18% taxable goods declared wrong in data GSTR 1 in the respective head of so and so. Then 3. The notice also cited that they did not avail any input which was not entitled. They stated that the invoices not appearing in GSTR 2 or appearing in GST 2A but not related to them. They also stated that GSTR 2A could not be made available to taxpayer on common portal during the initial stage of implementation. Then 4. They fulfill the condition of section 16(1), 16(2) and rule 37 of the act. They are in possession of the tax invoice debit note which were not found in 2A and issued by the supplier against the supply which they received against the invoices and were used in the course of furtherance of the business. The payment along with GSTR charges for the supply was made to the supplier as per provision of rule 37. Then 4. Section 73(1) of GST Act imposes.
So they were in possession of the.
Yes, they said it. They said so.
Then.
In paragraph
but
3.
It was not included.
Yes, Lord. That is their case.
Why?
Then Lord.
The seller has not done matter.
No. In your reply, you said you were
Yes,
in
my lord.
possession. You are in possession of the tax.
Yes, I am in possession of everything I have made. The uploading will be done by seller, my lord, in their portal. It is not my part and another act, my lord.
Then with regard to notification circular as read by my learned friend, that is clearly specified, and that is.
No, first it is for the seller. You have to recover it from the seller.
No, Lord, see what happened thereafter.
Unless it is.
Lordship,
the transaction itself is.
Lordship.
Not genuine.
Lordship, come to page 41 of the compilation submitted by learned friend.
Yes.
This is a judgment pronounced by the Honorable Supreme Court on 13/3/2023 relating to GSTs.
Yes.
I am directly, let me come to page 47, paragraph 14.
Yes.
I am reading paragraph 14 notes. Now, so far as the reliance upon the decision of Delhi High Court in the case of Quest Mercantile India Private Limited so and so, decided on 26/10/2017, relying upon by the Learned Council appearing on behalf of the purchasing dealers, is concerned. At the outset, it is required to be noted that before Delhi High Court, section 92G of the Delhi Veded Act was under consideration, which read is under 92G to the dealer or class of dealers, unless tax paid by the purchasing dealers has actually been deposited by the selling dealer with the government or has been lawfully adjusted against the output tax liability and correctly reflected in the return filed for the respective tax period. the burden of proof as per section 17 of KBAT Act 2003 was not as the issue before the Delhi High Court. How and when the burden of the proof can be said to have been discharged?
What does the Assam Tech,
No,
Assam
Lordship,
Act say?
No, CGST Act, Lordship, section
CGST.
16 to C.
16 to C.
16
to C.
Yes.
Section 2C, 16 2C says, subject to the provision of section 41, the tax charge in respect of such supply has been actually paid to the government either in case or through utilize of input tax credit admissible in respect of the said supply.
Read from section 2 and
Yes,
C.
2A.
No.
I'm reading section 2.
C is independent.
C is independent.
Uh.
Notwithstanding anything contained in this section, no registered person shall be entitled to the credit of any input tax in respect of any goods or service or both to him unless A. He is in possession of tax invoice or debit note issued by the supplier registered under this act or such other tax paying document as may be prescribed. Then 2AA, it was inserted in 2021. The details of the invoice or debit note referred to in clause A has been furnished by the supplier in statement of outward supply, and such detail has been communicated to the recipient of such invoice or debit note in manner specified under section 37. B has been received the goods or service or both. Explanation: for the purpose of this clause, it has been deemed that the registered person has received the goods or, as the case may be, services. 1. Where the goods are delivered by the supplier to a recipient or any other person or direction of such registered person, whether acting on an agent or otherwise.
So 16.2 says you shall not be entitled to the credit of any input tax
unless he has fulfilled this condition.
Subject to provisions of section 41, tax charged or so and so is paid to government either in cash or utilization of ITC. So 41 2.
41.
Is there an amendment to 41 2?
41 2. Availment of input tax credit. 1. Every registered person shall, subject to such conditions and restrictions as may be prescribed, be entitled to avail the credit of eligible input tax as self-assessed in return, and such person shall be credited to his electronic or credit ledger. Then 2. The credit or input tax as able by the registered person under subsection 1 in respect of sub goods or supply, goods or services or both, the tax payable whereupon has not been paid by the supplier shall be reversed, and the applicable interest by the said persons in such manner as may be prescribed.
You are relying on this?
Yes, sir.
You are saying that unless he pays, it gets reversed?
Yes, he has to revert.
There is no amendment to this?
Yes, there is no amendment. And Lordship, furthermore, Lordship, in the subsequent judgment of Supreme Court, Lordship, paragraph 15, page 48 of the compilation.
Page number?
Page 48.
48.
Paragraph 15. In view of the above, and for the reason stated above, in absence of any further cogent materials like furnishing name and address of selling dealer, details of the vehicle which has delivered the goods, payment or freight charges, acknowledgement or taking delivery of goods, tax invoices and payment particulars, etc. The and the actual physical movement of goods by producing causant materials, the assessing officer was absolutely justified in denying the ITC, which was confirmed by the first appellate authority. Both the second appellate authority as well as the High Court has materially erred in allowing ITC despite the concerned purchasing dealers failed to prove the genuineness of the transaction and failed to discharge the burden of proof as per section 70 of KBAT Act 2003. The impugned judgment and so and so was set aside. Here, Lordship, notice was issued there, but final order was passed. And there is a provision for appeal also under section 107.
My lord, what my learned friend is lying on judgment, my lord. Facts are different, Lordship. May kindly see facts.
So you explain to us section 41.
Yes, madam, I am coming, my lord.
41.2.
Section 41, my lord.
41.2 is very clear unless you say it is amended.
My lord, this 41 was substituted in my lord, on 1/10/22, my lord.
Hmm.
So this
And this,
transaction relates to 17/18 financial year, my lord.
Hmm.
This was effected, my lord, substituted from my lord with effect from 1/10/22, my lord. So it will be applicable subsequent years, my lord. My lord, fact of the case which my learned senior has relied upon, and that my Karnataka High Court, my lord, there was a specific finding, my lord, that transaction was not genuine by the assessing officer, my lord.
when was this notice issued?
My lord, this purpose was issued, my lord,
Hmm.
on 33/23, my lord. Just 25, my lord. 24, my lord. For the financial year 17/18, my transaction with regard to 17/18 financial year, my lord.
Now, why no appeal?
My lord, since my lord, division bench has held, my lord, that unless there is a genuine doubt of genuine transaction, my lord, that's why I'm relying upon the.
Division bench, that is not a finding.
But my
Division bench is given liberty to go ahead. It doesn't mean that
But
it will be an accept under the act.
I'm coming with two submission. First, my lord, while giving those findings, division bench has said all the so-called notice and orders, my lord. And the second thing is that, my lord,
Division bench, you'll have to read the order.
My lord.
You'll have to read the ratio in the judgment.
My lord.
That's all.
Ratio says, my lord, my lord,
Ratio is just giving liberty to the department to go ahead for those cases which are not genuine.
yes, my lord. In my case, my lord, there is no finding that is not genuine, my lord. First, my lord. Second, my lord, Lordship will see the circular they have relied upon, my lord. For that, my no so-called was issued the petitioner. Lordship will see the so-called notice. There was no charge.
So you can urge all this before the appellate forum. Why a report?
My lord, Lordship.
Why a report? Do you have a statutory remedy of appeal?
But my lord, I will be covered by judgment of division bench. That's Lordship. I approach this court, my lord. I'm praying, and Lordship will see the procedure they have followed, my lord.
Judgment of the division bench is that department is free to act on those cases where the parties are not bona fide.
Yes, my lord. There were so-called notices. In those so-called notices, there was no allegation with regard to, my lord, ingenuineness. That's why they have interfered with, my lord. In my case also, my there is no finding, there is no allegation, my lord, there is no transactional ingenuine, my lord. And my lord, the circular which they have relied, they have not followed the procedure, my lord. They never put me notice that you provide these things, my lord. Circular says proper officer will ask, my lord. He will seek details from me, my lord. In the so-called notice also, there is nothing wherefrom it can discernible that, my lord, the officer has ever asked these things to me, my lord. And only one line finding, my lord. Lordship will see there is no, it's not speaking order also, my lord. Only one line finding, my lord. He has not doubted my transaction, my lord.
See, Delhi High Court judgment,
my lord,
has to be read with the final order passed in the SLP.
Yes,
in the SLP, there was liberty granted to proceed against.
Yes, my lord.
non-bona
Even
fide.
in my case also,
transaction.
my lord, they can proceed. They found me, my lord. Lordship may remand the matter, but they can verify, my lord. They found, my lord, that something is wrong. They can proceed, my lord. Whatever details they can reach, I can provide, my
Go
lord.
in appeal.
But my lordship will see, my lord. Otherwise,
Why don't you go
I
in
will be
appeal?
in difficult because my lordship will just consider my prayer, my lord. First of all, there is no so-called notice with regard to the, my lord, finding of the circular, my lord. It is in violation of principle of natural justice, my lord. And lordship has seen the circular, my lord.
All right, Mr. KL, you file your response here.
No, Lordship, there is no difficulty in filing affidavit, but apparently, Lordship, the notice is clear and final
We'll
order is
examine
clear.
the question of maintainability.
Yes, my lord.
No, there is no difficulty, but section 41 is very clear too.
It was subsequent 22, my lord.
Lordship, the notice was issued in 23 after amendment and order was passed. So whether we can say that we have to
Prima facie, prior to amendment, the
that was the different.
provision of
Lordship.
the section was different.
Yes, Lordship, the notice was issued in 23 after amendment, Lordship, and final order was passed thereafter. So
In respect of a transaction prior to amendment.
even Lordship, if it is, but we have Lordship is to consider the amendment when it was effected, and admittedly notice was issued after amendment, Lordship. So the amendment will come into force, and it will be taken into consideration at the relevant time. There is a judgment to that effect also.
We'll examine, therefore we'll have to examine this.
No, there is no difficulty, Lordship.
Third, Mr. Misra, counsel appearing before the petitioner, CPL, hearing for the respondent department, the petitioner is aggrieved and has put to challenge the order in original dated 22/12/2023, passed by Superintendent GST and Central Excise Rogia 1A Guwahati, whereby a demand raised along with interest and penalty has been confirmed. Stop. Counsel for the petitioner submits that the issue stands covered by order passed by Division Bench in WPC number 2863 of 2020, another connected petition, whereby the Division Bench of this court, by order dated 5/8/2024, interfered with similar show cause notice, allowing the writ petition. So it is submitted that the input tax credit, which the petitioner sought to avail, was denied on the ground that the seller failed to deposit the required taxes for the transactions concerned. Referring to the provisions of the Act and read with the circular, as well as judgment of Delhi High Court, which is also referred in the order dated to and so passed by this court, counsel for the petitioner submits that the liberty granted to the department is only on a finding that the benefit claim was non-existent or incorrect or not bona fide. So, referring to the impugned order, he submits that there is no finding that this order was, that the claim of ITC benefit sought for by the petitioner was not bona fide. Under such circumstances, he has filed his writ petition questioning the very jurisdiction of the authority in passing the impugned order. Mr. KL, as well as Mr. S.K. Bedi, counsel appearing for GST and of India, submit that they would like to complete their instruction. Mr. KL, the other end, however, strongly disputes the contention raised by the petitioner and submits that there is a statutory appellate forum provided where the petitioner can file an appeal and for redressal of his grievances. It is also referred to the judgment of the apex court rendered in
Page 41, Lord.
State of Karnataka versus Swinto, where he has referred to the finding of the apex court that the onus or the burden of proof of the transaction on which the input tax credit is claimed is of the purchasing dealer. So therefore submit that since the petitioner could not furnish adequate material before the competent authority in response to the court issued, the order was passed. There is no infirmity in the order, and same is not required to be interfered with. Whereas, having heard an account party, the issue notice returnable. There is one more submitted recording. Mr. KL also submits that the provisions of the relevant section is section 41. 41 with bracket 2 was amended and the amendment was brought into effect on 22. When?
Yes, my lord, on first 1/10/2022, my lord.
1/10/2022. And the show cause notice was issued in the year
23, my lord.
the year 2023. Therefore, any benefits ought to be availed of by the petitioner to the pre-amended section is not available to the petitioner. So, the issue notice returnable 4 weeks. Since the respondents are represented, notices are waived, extra copies are furnished. Respondents may complete their instructions and provide necessary affidavit. Meanwhile, coercive measures shall not be adopted by the respondents in respect of the pursuant to the order, appeal order dated 12, the next returnable date. That will be listed again on 20 January.
Much.
May I please talk?
Chips, in terms of his, my learned friend's prayer, his appeal has been disposed of by the respondent number 2 by issuing a direction to the DLSA Golaghat to do the appropriate, the needful by passing an appropriate compensation of 5 lakhs. If I may just place the order.
Have you received a copy?
Yes, sir.
Paragraph 19 and 21, page 7, Your Lordships. Your
Heard counsel for the parties. The grievance of the petitioner is that in response to the appeal filed before the Assam State Legal Services Authority, no orders have been passed and the appeal has been kept pending. Stop the appeal was filed for enhancement of claim.
Yes, sure.
Which was awarded by the District Legal Services Authority,
Golaghat.
Yes.
Golaghat. So, this court, by order dated 18/11/24, directed the standing counsel for Asalsa to obtain required instructions. There are 2 days. The learned standing counsel has placed before the court the order dated 26/11/2024 and submits that the appeal was disposed of, directing the DLSA. Appeal was disposed of, and the claim of the petitioner was modified and enhanced to a fixed amount of rupees 5 lakhs. And the District Legal Services Authority, Golaghat, was directed to complete. Was directed to pass final orders relating to the enhancement of the compensation and take all required steps. So, relevant portion of the order is expected at 19/20/21. So, in view of the order being passed and taking note of the limited prayer in the writ petition that a direction be issued for disposal of the appeal, N, the appeal having been disposed of by the order dated 26/11/2024. No further claim that the petition survived. Therefore, petition is dismissed as not pressed.
Worship. Direct the respondent number 3, the
Already
claim of the-
directed. Why further direction is
because
required?
our petition respondent number 2 and 3 also, Your Lordship.
Huh?
Respondent number 2, 3 also there.
Is disposed of in view of the order dated so and so. The respondent number
3, district
three
legal circle.
will take all necessary steps to comply with the directions contained in the order dated so
In
and
his petition.
Writ petition accordingly stands disposed of by Mr. R.S. Chaudhary for Salta, Mr. Daniel copy. For
one
sale.
and three.
1 and 3.
So grateful.
Copy of this order placed before the court is kept on record.
So,
Be privileged.
please, Your Lordship. On the last occasion, they were supposed to obtain instructions, my lord, whether this present application is covered by the.
It will be covered, my lord, because they have initiated the, my lord, 73-1 proceeding without issuing the so cause. Only that, my lord, summary of so cause was issued.
What was the direction passed? This order.
I'm giving the,
Where is that order?
my lord, I'm providing.
Why don't you enclose all this?
I'm sorry, my lord. My lord. Para 29, my lord, page 24, para 29, my lord.
Okay, so no notice except for the
Yes,
summary.
my lord. In fact, my lord, the section 73-1 specifically provides that we'll have to issue a so cause.
Yes, please.
9 and 10 are similar.
9, 10, same.
8, 9, 10 similar.
Similar. Oblige, Your Lordship.
Thank you, Your Lordship. My lord, item number 11 with that item number 56, a miscase.
I,
No, thank you, my lord.
56. 56.
56, man. 3643. I filed an application for amendment of the cost title, inserting the name of the private respondent.
So 7 and 8.
My lord, from
In your IA,
my lord, along with that, I have filed another miscase, my lord. Amended cost title. After this is allowed, my lord, we will file the amended cost title.
you don't have to file an application for amended post title. Direct the sequel.
It's true, my lord, because we have filed. It is not there, my lord. It is not there.
What is not there?
That amended cost title we have not filed because after this is IA is allowed, then we can file this amended cost title.
Oh, IA is for implement.
Implement.
If there is a direction for implement,
My lord.
the order for amended post title will follow automatically.
My lord.
No,
Names on the, my lord, in the prayer at page 5 is that
On implement or petition.
Implement petition is not there.
It's not there.
Not there. This is only, the prayer is that, my lord, instant incorporating the names of the members of the board of directors. Page 5.
You have filed a writ petition.
And my lord, and
now you want to implement certain.
my lord, so I'm to say, because there was no notice and nothing was issued, so I want to amend the cost item by inserting the name of the names of the members of the board of directors.
No notice was issued.
No notice was issued.
We had passed some order.
But only that I have prayed for implementing the name.
Uh,
So, my lord,
not
that
implemented.
not implemented. That is why, my lord, I am asking for, praying for, my lord, to.
How can you change the course title without an order of the court?
No, that is why I have.
So what order can we give you unless you make a prayer for it?
No, this is what I have made a prayer with this application.
No, this prayer is for amendment of the course title.
My lord, for amendment of the cost title, for
Why should
inserting.
we allow an amendment of the course title?
But
Unless
so-
there is a prayer for implement.
Well, here is the prayer for implementation. The prayer is this, my lord. Page 5. Amendment cost title, instead incorporating the name of the members of the board of directors.
You are an astute, seasoned counsel.
My lord, only thing you want to, lordship wants to place it that I have to file an application for implementation.
There is a procedure.
My lord.
You want to withdraw and file afresh, we have no problems with that.
My lord, your lordship.
There is an order.
Well, your lordship may direct that we'll withdraw and file it on.
Instead of filing this, you could have filed an amended petition. It would have saved your problem.
But the amended application is along with us. But my lord, that we have given served them a copy also. My lord.
Now you want to withdraw, you want to file an amended course title.
My lord, your lordship then allow us to amended cost title. We'll file the amended cost title.
Amended, sorry, implement.
Implement. Your lordship, if we go for an implement, your lordship will allow us to withdraw and file it on.
That's the
that is better.
Learned counsel for the petitioner to withdraw the writ petition as certain respondents were not implemented. He gave leave to refile the same after making the necessary correction. Prayer made is allowed. Writ petition stands dismissed on withdrawal with liberty. In view of the order, IA, you write, in view of the order passed today, in the petition to enter, IA stands dismissed.
13 also same, man. 13 and 57.
13 and 57.
13 and IF 57.
So 11 along with
56.
33.
11 and 13, 56 and 57. Their names may be shown.
My name may be recorded, Lordship. I'm for Kibir. Respond number 7, Lordship.
Mr.
MK Hussain.
MK Hussain. Appears for the caveators.
Caveators?
Both the staff. Yes.
She may record my senior counsel's name. SK Talukdar.
SK Talukdar for Cooperation Department. Both the matters. As well as in the IA.
With the liberty to file it.
We have given you both the matters. Liberty. 11 and 13. Along with item 56, 57 and the IA.
That is your lordship. The demands has already been complied, your lordship.
It is submitted by the council that by me that does not wish to press the writ petition any further. Accordingly, the writ petition stands dismissed as not pressed. The petition stands completed. N. Goswami appears for the
1 to 4.
Respondent 1. Yes.
May I please, your lordship? In this case, your lordship, the husband of the petitioner had been expired due to hit by unknown vehicle, your lordship. And the unknown vehicle till date, your lordship, has not been traced out. And concerned police station submitted FIR, your lordship. I'm placing FIR, your lordship.
FR.
FAR.
FAR.
Yes.
Or FR.
FAR.
Accident report.
Yes. If your lordship will file second page, your lordship, serial number 8, vehicle of registration number is unknown, your lordship. number
So what is the stage of the investigation, Mr.
Your
Robbie?
Lordship, on the last occasion, he had submitted that he has got a notice from DLSA and he was required to apprise this court as to what has happened after she appears.
Yes, Lordship. As per the instruction of my clan, Your Lordship, on that day, petitioner appeared before the concerned office, and concerned office take a statement and take some documents, Aadhaar card, voter ID.
Concerned office means DLSA.
TLC.
DLSA, Your Lordship.
Okay.
And father has
It
not
is,
been
to
provided.
my verbal instruction, Your Lordship, it is pending at the stage of investigation as to
Yes.
whether they're entitled to this claim is correct or incorrect or whatever. Since the case has already been taken up by DLSA, there's no question of
Then the DLSA completed the strike.
investigation.
This is a notice may be issued.
Huh?
At this stage, Your Lordship, notice may be
No,
issued.
no.
Otherwise, they will keep pending
If
again.
the DLSA has already
Taken a step after
taken
filing this
step.
writ petition, Your Lordship.
Whatever, we'll record that
Lordship.
and we'll close it.
Lordship, with liberty.
With liberty.
Why no liberty is required?
Because an order will have to come.
Either
from
the
DLSA.
DLSA will say yes or no.
Yes or no, correct.
In which case it becomes a fresh cause of action.
Yes, Lordship.
No liberty is required.
Lordship, if they
You are
keep
filing
pending
a petition.
several years, then
You are filing a petition seeking a direction
yes, Lordship.
for them to act.
Yes.
Meanwhile, they've already started acting. Right?
Lordship,
this
right,
action-
but
This
if they will take a step prior to filing this petition, that's another thing. Because after filing this petition, they are taking it.
that's good.
So
They're scared of you.
Okay, Lordship, as your
Had learned counsel for the parties. This petition is filed by the petitioner. Do you have a copy of the notice received from DLSA?
Yes, Lordship.
Give it to us. Seeking a direction to the respondents. Grant compensation to the petitioner under the Assam Victim Compensation Scheme 2012, notified by along with read with notifications dated 18/10/2012 and 1/2/2019. So it is the submission of the counsel to the petitioner. The husband of the petitioner expired in an accident, in a road accident, and the vehicle and the offending driver and the vehicle has been untraced so far. Under such circumstances, he has approached this court as his claim was not considered by the District Legal Services Authority. So he has approached the same. So learned counsel for the petitioner has placed before the court the first accident report received from the concerned police station, where
Police.
from the Busista police station, and where have you said it is untraced?
Yes, Lordship. Second paragraph, Lordship. Second page, paragraph number 8, Your Lordship. Unknown.
Where he
Unknown, Your
referred to
Lordship.
the details,
Right.
particulars recorded in the FAR, that is first accident report. He submits that at column 8 of the said FAR, vehicle number, vehicle registration number and details are shown to be unknown. So, whereas this court on 22/11/2024 permitted the respondent counsel to obtain required instructions. As it was submitted that the petitioner has received some communication from the office of the DLSA, Kamrup Metro. So today, the counsel for the petitioner has counsel to the respondent submitted that DLSA is already has already taken up the matter, and notices have been issued to the petitioner, and pursuant to which she has appeared before the DLSA. So, learned counsel for the petitioner also submit that the petitioner has appeared before the DLSA pursuant to a notice dated 21/11/2024. Copy of the notice is placed before the court. Since it is seen that the DLSA Kamrup Metro has already is already taking up the grievance of the petitioner. No further direction is called for at this stage. Stop. The writ petition accordingly stands closed with the observation that the DLSA will look into the grievances of the petitioner and pass appropriate orders thereon. Any order that is passed, copies will be served on the writ petition. Petition stands disposed of in terms of the above.
Stop.
My lord, item 15 and 16 may be passed over for time being. As
Lordship,
the
Lordship, in this case, we have not also received instruction, Lordship. There are some directions to bring some instruction, Lordship, that we have not received. Lordship.
Next week,
Next week, Lordship.
a joint request matters be listed next week.
highly object.
Your Lordship, my lord, your Lordship may peruse the order dated 20/11/2024.
Sir, in this case, also, Lordship, we have not received the instruction.
Next week?
Interim order to continue. Interim order is there. If money is not paid, that it will not be paid.
All right, matter be listed again on 4th is all right, or
month
6th? 6th of December. At the request of Government Council, interim order passed early will continue to the next day, please.
All right.
What is that?
Lordship, the petitioners are brothers in relation, Lordship, and are co-owners and possessor of a plot of land measuring 0 viga 1 kata 5 lisa, Lordship, which were allotted to them by the respondent number 3, Lordship. Kindly peruse page 21, Lordship.
We issue notice today. Will
Lordship.
issue notice.
Lordship.
Heard and counsel.
P. Bodle, Lordship.
Petitioner P. Bodle. And MS RB Bora appearing for
Respondent number 2, 3, and 5.
2, 3, and 5. MSPR Monto for respondent 1, Mr. N. Goswami for respondent 4. Notice returnable 4 weeks. Since the respondents are represented, notices are waived, extra copies will be furnished within 1 week.
Lordship, one prayer, Lordship. Lordship, my simple prayer is that the petitioners may not be evicted from their land without following the due process of law, Lordship. That must, Lordship. Because we are occupying the land, notices were issued to some other persons. We are not issued notice, Lordship.
So
That
why are
must,
you
Lordship.
apprehending eviction?
Lordship.
Why are you apprehending eviction?
Because officers are coming, Lordship. And a national highway project has been going on in that particular area, Lordship. That must, Lordship, without following due process of law, because allotment order is with us, Lordship.
If you receive anything, you are entitled to come and bring it before the court.
Lordship,
This kind of blanket orders will create complications for you as well as for the respondent.
Lordship.
So if there is any threatened eviction sought to be done, you can always file an IA seeking appropriate orders from the court.
Lordship.
Right?
Lordship. Lordship, item number 19, same.
Item 19 say.
Oblige, your Lordship.
Yes, Mr. Soikia.
My lord. Land was acquired in 1997 now. Originally in 75. 1975. Then again issued notification in 1997. But compensation was not paid. And while we approached the Honorable High Court, under the High Court has passed the judgment at page my lord, 62.
So we'll issue notice today.
Yes, my lord.
Heard Mr. R.C. Soikia, learned counsel appearing for the petitioner. MSPR Monto for respondent number 1.
I'm for 1, 4, and
1 and 3. Mr. N. Goswami for
4 and 7.
4 and 7.
My lord, I am for respondent number 2, 6, and 8.
Mr. Bora appears for respondent
2, 6, and 8.
2, 6, and 8. And who's for PWD? Who's for PWD? PWD building, who's there? Huh? Mr. N. K. Nayak appears. Respondent number 5 and 9. Since the councils are represented, respondents are represented by the council, notices are waived, extra copies be furnished within a period of 1 week.
Interim prayer may be kindly considered on the returnable date.
What is your interim prayer?
Interim prayer because the money has been sanctioned now amounting to rupees 24 crores. If the money is taken away by somebody, it will get difficulty. That may be considered after hearing the malot on the returnable date.
Interim prayer will be considered on the returnable date after the
After good hearing the lot.
It's showing the name of XPW in the
complete their instructions. Registry to reflect the names of all councils appearing for the, including councils appearing for the respondents in the course case.
Obliged.
Yes.
My lord, this matter regarding compensation, my lord, for land acquisition, my lord. National Highway, my lord, has taken land of the petitioner, my lord, processing, but no, my lord, compensation thereof is paid, my lord. Similar Pattada, my lord, have approached before this honorable court, my lord, and page 141, annexure 10, my lord, notice is issued. This is WBC, my lord, 5578, 2024.
All right, heard council to the party notice. Returnable 4 weeks.
Yes.
Mr.
Monta.
PR also appears for respondents 1 and 3. Mr. Goswami for
4, 5, and 7.
4, 5, and 7. National Highway.
3 and 2, or 2 and 6.
Singh for
2 and 6.
respondents 2 and 6. Respondents we served with counsel for the respondents, we served with extra copies within a period of 1 week of today. Respondents may complete their instructions and file necessary.
Well, kindly, this matter may come up along with this matter.
They
WPC,
submitted that a similar matter is pending before this court, and accordingly, the said matter be listed along with
WPC, well, 5578 of 2024.
5578 of
2024.
2020.
Deep number.
When is this matter listed?
My lord, this is listed, my lord, it is fixed, my lord, on, my lord, 9/12/2024.
Then you
Isn't it
make
short?
it returnable on 9/12. It will be listed along with this matter. Okay.
Obliged.
Please, Your petitioner has filed an online application for partition of his land, my lord, annexure 5. And thereafter, appeal also filed, my lord. And similar page number 28. On track consignment, my lord, it is stated that, my lord, fully resolved.
We issue notice. Here, but we issue notice. Returnable 4 weeks. MSPR Monroe appears for respondent number 1. Director Land Records. You will appear 1 and 2. Mr. S. Borua appears for
3 and 4.
3 and 4. The respondents appear, notices are waived, extra copies will be furnished within 1 week. This recording.
Obliged.
Should kindly pass over the matter for the time being.
2 p.m.
Your much obliged.
That is your lordship. I thought expect a pertains to Milord and non-payment of compensation Milord. In this regards, Milord, the without prior issuance of notice Milord, petitioners Miadipatta length acquired and constructed a bridge Milord. During construction of bridge, certain portion of my house also Milord demise Milord. In this regard, Milord, inquiry conducted and it is found that yes, certain the construction they have done Milord over my land Milord. In this regard, Milord, since certain facts are also involved, I last year made. Kindly have a look on page 26 and 28, Milord. This is my last application before the authority concerned, Milord. In page 26, Annexure 6, Milord. Mainly ground in 3 and 4, Milord. 4. And finally, Lordship will find page 28. This is the last application pending before the authority concerned. And since my prayer before this honorable court, since these are applications yet to be disposed of or considered, even I requested them to hear all the government officers and including me and all records. Can you come to a conclusion how much compensation I'm entitled to? That is in page 20 and Annexure 7. If this honorable court directed the authority concerned, the Annexure 6 and 7 may be directed in time out. Let me, my relief will be get me out. The purpose is
your applications do not reflect that.
Well, Lordship will find the first page.
Or 27 is one.
27, not 27.
And 29.
27 is the vernacular, Milord. 26 and 28.
Which application do you submitted? 27 and 29.
Milord, page 26, Annexure 6 we submitted on 17th of April 2024 before the Executive Engineer PWD. And finally, Milord, before the District Commissioner Respondent number 2, that is on 24/7/24.
Yes, Mr. Naik.
Lordship, if you know, bridge is being constructed, Lordship, over the land of the petitioner. I mean, Lordship, his land falls below the bridge, Lordship.
He is asking for damages caused by your JCB to his house. So,
Lordship, let me have instruction that.
let him have instruction.
Yes, yes, Lordship.
Petitioner is agreed by non-consideration of his representation filed before the Executive Engineer PWD South Salmara Pankachar, which submitted on, it was received on 17/4/2024. The petitioner has prayed for grant of compensation in respect of the damage caused to the house by the JCB employed by the PWD department or its agents. A similar representation was filed before the Deputy Commissioner South Salmara Pankachar, which was received on 24/7/2024. So, however, no response is forthcoming from the authorities, and consequently, petitioner is before the court. Mr. K. Nayak and Mr. S. Murwa will obtain respectively instruction from the PWD department as well as the DC South Salmara Pankachar district. Then council will furnish additional extra copies.
Yes.
The respective council to obtain the instruction. Place this matter again on
Nova.
Sixteenth.
Milord. For motion, Milord.
For motion.
Yes, deeply obliged.
Maybe the Lordship. Not we have challenged the my lord input notice, my lord, page 22, my lord. Page 22, this notice has been issued to one of the tenant of the petitioner, my lord.
Where is the notice?
Page 22, my lord.
Yes, so
My lord, the house is situated, my lord, over the patta land of the petitioner, my lord. Kindly see, my lord, page, my lord, 15. It's a terrace Medi Patta, my lord. Vernacular is page 16, my lord. Then, my lord,
you are creating some structure for running a grocery shop.
yes, no, this is some type house, my lord, where grocery shop and other shop also there, my lord. Now they want to remove that construction, but they have to acquire the land, my lord, first, my lord. Assessment should be made, my lord. This is in the land of the patta land of the petitioner, my lord. This type of notice cannot be issued, my lord, in respect of patta land of the petitioner, my lord. First, they have to, my lord, assess the, my lord, value of the house and land, my lord.
Yes, Mr. Nayok.
We will pay,
perhaps
my
some
lord, but they have to
instructions.
pay compensation, my lord.
Let it also come on 16th.
Lordship.
Third learned counsel for the party. Petitioner claims to be the owner of Patta land, comprising of 1 figure 3 quota 14 lecture, covered by tag number 570, Patta number 397, at village Haldi, part 2, of the Bilatripara Revenue Circle district of Delhi. So, petitioner had constructed an Assam type house, and in that house, several shops are running on a rent basis. So, by a notice dated 14/11/2024 issued by Eastern Executive Engineer PWD Veer Singh Jarua TR Road Subdivision, Bilatripara, petitioner was asked to dismantle and remove the Assam types house by 30 November 2024. Stop. It is the submission of the council for the petitioner that this is his patta land, and if the respondents want
50/50
the respondents cannot issue the impugned notice without first acquiring the said land as per procedure prescribed in law. So, he therefore submits that the notice itself is illegal and without jurisdiction, and has prayed for appropriate orders for interfering in the same. At this stage, the court is of the view that the Standing Council PWD can be permitted to obtain the required instructions. Let Mr. P. Nayak obtain the required instructions in the matter, for which adequate extra copies of the writ petition shall be served by the council to the petitioner within 2 working days. So, let the matter be listed on 16. Meanwhile, no steps taken by the PWD department pursuant to notice dated 14/11/2024 till the next date fixed 16/12.
Publish, my lord. Yes, my lord. This is, my lord, regarding, my lord. Actually, in this case, my lord, the mother of the petitioner applied for, my lord, settlement of allotment of land under scheme Bosundara 2.0, my lord. That has been rejected, my lord. In the meantime, mother, my lord, died, my lord. Thereafter, my lord, petitioner submitted an representation before the deputy commissioner, my lord. But till date, no action has been taken to that effect, my lord. Application acknowledgement page 32, my lord. And rejection, my lord, kindly see page 33. Page 33, operative portion page 34. Thereafter, mother died, my lord. Mother died on my lord 16/6/24. Then, my lord, petitioner filed a representation case 38, my lord. So at this stage, my lord, notice may issue, my lord.
Heard also to the parties. Next topic.
Okay. In this matter, already the petitioner has submitted that previous application of his mother has been rejected and the reason stated very clearly. Now, after the mother, the petitioner has come into the picture. So he has to apply afresh in the format with all the necessary documents.
Get your instruction. You get your instruction.
Yes.
Right. You notice written about 4 weeks. Here, here correspondent party. 3 also no. 3, 4, 5, Mr. S. Things come to the clear step. This is the way partition. List of the kind of thing.
Bless me.
My lord, as per the order of the honorable court, my lord, he has submitted another, my lord, representation and also filed an additional affidavit, my lord, on 26 yesterday.
So DC will direct DC to pass order. What else? You have submitted it on 25/11.
Yes, my lord. On 23rd, it was a holiday, my lord.
No, that's
So
okay. 25th you have served.
Yes, yes.
Mr.
This is the copy, my lord.
Borua and Mr. Dotto. Let the DC examine it.
Yes.
Third learning council. Parties, this by petitioner.
Tamil Heri myself ordered a case
States that he is the president of Kurmara Rise Goira,
Goira.
and other four village. Stop. The petitioner, in his capacity as the president, was requested by the secretary of 15 number Champok Nagar Gaon Panchayat, Toigaon, to select the presidents for the 3 construction committees to carry out work under the Atorho Ram Yojana. Stop. The president, the petitioner, and the secretary submitted proceeding the meeting held on 23/5/2024 in the office of the Gaon Panchayat the same day. So, but instead of constitution of the construction committee in terms of the names proposed by the petitioner and the secretary of the Gaon Panchayat, the local MLA constituted a construction committee with people of his choice. And as a consequence thereof, the respondent number 4, that is the DC,
District Commissioner.
District Commissioner Kamrup, by issued a notification on 1/11/2024.
My lord, it should be 110, my lord.
1/10/2024 on the basis of the notifying the said committees comprising of the names inserted by the local MLA. Stop. Submitted that same is violating the guidelines laid down for Atorho Gram Yojana. Petitioner submitted a representation dated 5/1/2024, but no steps have been taken by the DC. Stop. The matter was listed on 22/11/2024, on which day the petitioner was permitted to complete her instructions with regard to any representation being furnished before the DC. So today, an additional affidavit has been filed, enclosing a copy of the representation dated 25/11, placed before the filed before the DC. So we said a representation was received or was shown to be received on 25/11/2024. So it is submitted that in spite of the representation being filed, no order has been passed by the DC in respect of the grievances raised. So the writ petition was filed for directions to the DC to pass necessary orders. Learned counsels for the respondents submit that they have no instructions. The specific prayer in the writ petition is to set aside the notification dated 1/11/2024
10, my lord.
1/10/2024 passed by the Deputy Commissioner.
To supplement.
Kamrup by the memo number so and so 10, page number 10. So in spite of the representation filed, no orders have been passed by the DC redressing the grievances raised. Under such circumstances, this court considers it apposite to close the writ petition at this stage without issuing notice, but directing the respondent number 4, the Deputy Commissioner Kamrup, to pass appropriate orders on the representation filed by the petitioner, highlighting their grievance. Any such order to pass, a copy thereof can be served on the petitioner. The DC will pass necessary orders within 2 weeks.
Yes,
2
sir.
weeks.
2 weeks will be too short.
Already, I'm started.
Let it be 3 weeks.
Yes. Because passing an order, that's all. Because they are apprehending the
Yes,
initiation
yes.
of construction. Two weeks from the date of receipt of the certificate.
Receipt of certified copy.
Be submitted by
Yes.
the
Petition.
council for the petition. So, the petition accordingly stands closed with terms of the above. Direction. Mr. Borua and Mr. Dotto appeal the court.
Obliged, my lord.
May it please your lordship. My lord, the order impugned is at page 35, and the translated copy is at page 34. Your lordship will find at page 34, an eviction notice issued without giving the proper notice. My lord, after the reference, the division bench in Salakuddin has said in para 61, because under paragraph 29, 30, 31, because under section 6 of the Assam Land and Revenue Regulation, we get an adverse position right, we can claim right over a caste land to adverse position, which has been decided by the division bench. And my lord, division bench in para 61 has said that notice has to be given individually to everybody. Then on the representation filed, they will decide about the bona fide claim, then only they can evict them. But here the notice was given in general. My lord, if your lordship just looks into that judgment, my lord, para 61, my lord, it starts at page. Your lordship can kindly look into this judgment. And the relevant para is 29 to 31 and para 61, where it says about that one. Para 61 I have marked, my lord. And it has also dealt with section 6 of the Assam Land and Revenue Regulation, which says that under section 26 and 27 of the Limitation Act, I can. Paragraph 61 is relevant first, my lord. Paragraph 61. Every individual possessor has to be given. Another 11 paras are 29 to 31. And in para 32, the Honorable Division Bench has held that Radha Kanu's case of Toji Behra has only decided about 18.1, not about 18.2 and 18.3. In para 32.
These are what land? Government land?
Wasteland, government khas land. Khas land. And para 29 to 31, it has said that bona fide right, because I can claim right as per section 6 of the regulation.
What do you do there? I mean,
My lord, from prior to 1966, I have our residence, we have our electric bill, we are paying Toji, everything is that. We have applied for also, my lord. We have applied for settlement also. Nothing has been decided on that. And now they have given a jail notice.
yes, respondent who was there. What do you say?
Ultimately, he's without his consideration of his application. Now this notice has been issued. So let notice go here till the time returnable date.
Heard name of the is that they're in possession
2008
of
no application.
government khas land,
Application. Settlement.
which they have inherited from their parents.
Annexure 10.
Stop the parents of the it land has been in possession of the petitioner and their parents since 1966. Have you given any particulars of the petitioners?
My lord, I have given where, my lord, I have given annexes to all those flag numbers and at
In
para.
the writ petition.
Writ petition, my lord, I have stated in para.
Electricity bill and
I have given electricity bill and others I have given. My lord, para 2 I have
There are
stated.
5 petitioners.
My lord, I have given para 2.
Okay. The particulars of the land under the possession of each of the petitioners are described in para 2. It is submitted that while they were continuing with their day-to-day life, petitioners were served with a notice, page 34.
Page 34, a general notice.
General notice dated 13/11/2024, putting them to notice for eviction under Rule 18 of the Assam Land and Revenue Regulation, 1886. So, Learned Counsel for the petitioner submits that the recent judgment of a coordinate bench rendered in. So this is the division bench.
Division
bench rendered in Salakuddin versus State of Assam, reported in 2024-6 GRR 614. It's that this court has returned. This court has held that the occupier or possessee has to be put to notice as to whether he has the bona fide claim of right to law. Where does it say individual notice?
My lord, that para 61, possessor, every possessor should be given a notice. Otherwise, my lord, in jail it cannot be.
Oh, kindly point out the line.
My lord, in para
Statement.
61, para 61.
Please read.
My lord, the book is your lord. Para 61, my lord. It is stated, I marked over there, my lord, in there, every possessor has to be given a notice. Individual. Sorry, my lord. My lord, Under such circumstances, for the purpose of just, fair, and transparent procedure, the occupier stroke possessor has to be put to notice as to whether he has a bona fide claim of right involved. Moreover, if the stand of the
What is the
occupier,
name of the citation?
my lord,
The case name, party name?
Salakuddin versus State of Assam. And my lord, from paragraph 29 to 31, it has said about bona fide claim. And para 64, your lordship will find, it has said, we accordingly answer the reference holding that the prior to initiation of proceedings under Rule 18.2 of the settlement rules, the occupant possessor of the government land had to be issued notice.
Can you give us the citation?
Citation, my lord, here it is 2024, 6 GLR page 614.
Report is not available. No, I don't see every possessor. It says they'll have to be put to notice.
That's true.
My lord, notice, my lord, if I cannot claim my bona fide on a general notice, my lord, that's page 60.
Saying that the court has said the subject to character issue was under 18, whether a notice is necessary or not.
Yes.
My lord.
Earlier, the law was since you are occupying in government land,
No.
ordinarily required, but even if not required,
It forthwith
cannot be
can be given. That is
violated.
2006 GL 3 GLR page 99.
Subsequently, section 18, at least you are entitled to a notice to establish your bona fide claim.
My lord.
But to say that each person has to be
My lord, in the alternative, I have paid a settlement immediately on the notice. I have placed my bona fide claim. I have raised all this
whatever it may be,
But they have not decided.
that's a different issue.
But my lord, the language is, my lord, subject, my lord, all, my lord, holding that prior to initiation of the proceeding under 18.2 of the settlement rule, the occupant, stroke, possessor of government land. The word is occupant, stroke, possessor.
You can't say that you have not been put to notice by this.
Well, it is whether my submission was whether it was a proper notice or not.
That's right.
My lord, my submission, notice was given and I have played, if I take it in the alternative, notice has been given, I have played.
Is that the division bench has held every individual has to be given a notice. That we don't find it.
That's true.
My lord, in the alternative, if I place it, my lord, in that para 61, if I take this as a notice also, I will place my bona fide claim and they will decide it, then they will effect.
Correct.
I have immediately placed before, my lord, and they have received also.
This notice was issued. General notice was indicating the revenue village and the dark number. Your dark numbers are included here.
My lord.
Dark numbers of the petition are included. Notice reflected. And immediately thereupon they have filed an application before the district commissioner. Walpara. To okay, there is a Beltola in Valpara also. Giving details of their particular. However, till date, no such orders, etc. have been received on the representation side. So, the petitioners apprehend that since the notice was issued on 13/11/2024 and a 15 days time was granted to the petitioners, the authorities, having not decided on their claim, may take steps to proceed for eviction by demolishing their homes and homestead in violation of the rules and procedures. So they therefore have filed this petition seeking an appropriate order. Mr. S. Murwa appears for 2, 3, and 4. MHPR for respondent.
No, no, no.
Mr. P. Nayak for respondent number. Oh, you are for 2, 3, and
4.
4 is PWD.
Yes, only 2, 3.
So who is for number 5?
To register both.
No, that has to.
But it is represented by the district commissioner.
They can
I'm not sure about this committee, District Road Safety Committee.
All right, you accept notice now. Respondents 2, 3, and 5. Nayak for respondent number 4. Let the respondents complete their instructions and pass necessary orders. Complete their instructions and file necessary counter affidavit to advise. Stop till the next day fixed. No further steps will be taken in respect of the writ petition by the respondent pursuant to the notice taken. Thirteen 2011. Sorry. 13/11. Why can't you get instructions? How soon can you get instructions here? 1 week?
Yes.
Let the matter be listed on 9th. Let the respondents take their required instructions. Extra copies be furnished within the course of the day.
Your lordship has protected that.
Yes. Till 9.
Till.
May I please, your lordship?
Complied?
Lordship, my lord, some technical issues of the software of the Government of India, my lord. It's not complied here, my lord. We are taking the issue with the Government of India, my lord. Within a short time, we will comply.
How short? How short?
My lord, lordship may grant 2 weeks further time may be granted.
Mr. S. Dotto, counsel for the respondent.
Sole
respondent. Further 2 weeks time. Respondent?
Sole respondent. So respondent number 1, man.
For all the respondents?
All the respondents.
For further 2 weeks time. Let the matter be listed after 2 weeks, by which time it is expected that the respondent will comply with the directions contained in the order dated so and so passed in the for the petition.
As per official note dated 22/11/2024, published upon respond number 3 and 7 completed.
As per office note dated 22/11/2024, service respect to respondent 3 and 7 are completed. Let the matter be listed for admission.
I'm appearing for respondent number 7.
Mr. Your
As-
name?
as Biswas.
As Biswas. Appears for respondent number 7. How much time do you require? Any response you want to file?
Yes. No more, not yet. 2 weeks, my lord.
2 weeks. The respondents will file their necessary counter with by the time matter be listed on 8th of January.
July.
My lord, in this matter, my lord, I am appearing for the respondent number 1, my lord. For respondent number 1, my lord, his part is over, my lord. Now the proposal is pending before the government in PNRD department, my lord. Although he is not a party in this matter, my lord, but I'll take personally instruction, my lord, whether complied or not, my lord.
Where is the order?
Order
Direction of the court?
9.
Is 9.
When start from 9.
And relevant by page 13, Lord. Relevant on page 13, para 10.
No, the direction is to respondent number 2, Commissioner, to release the amount.
My lord. My lord, commissioner is not the appropriate authority to release, my lord.
We don't know.
Yes, my lord. That is why we have,
Direction of the order.
may I also this instruction, my lord?
We are concerned with whether the directions have been complied with.
My lord.
Now, if the directions are not proper,
My lord.
you should have filed.
Lordship may grant
Application.
further 3 weeks time, my lord. We are trying our best.
We can't say that the commissioner has complied and
My lord.
the direction is to the commissioner to disburse.
Yes, yes.
Mr. Dottrol and his counsel appearing for the respondent prays for 3 weeks further time to complete his.
But
Mr. K.D. Sharma for the placed after 3 weeks.
But highly obliged.
Yes, Your Lordship, kindly see order, office note dated Lordship 25/11, Lordship. Neither AD or nor unserved notice returned by Lordship.
As per office note 25/11/2024, service report is awaited placed after 3 weeks. And it's going to appear for the petitioner. Yes.
I am for Respondent 1 and 2, my lord. Only the legal point involved in this case, my lord, whether the co-owner give lease, my lord. Whether co-owner can give lease, my lord. No, we have rejected the claim of the petitioner on the ground that all the co-owner of the piece of land did not execute the lease deed, my lord. That's why we have rejected their candidacy, my lord.
There is a judgment of the court on this point.
No, we come to Supreme Court in 2009, 10 XCC 654, unless there is a partition, my lord. The leaser could not, or the owner cannot give his land, my lord.
Yes.
My lord. Page 98 is the impino, my lord.
This is for what? This is for orders.
Yes, madam.
Why is it come for orders?
No, we have not filed an affidavit, madam.
You want to file or you don't want to file?
We will produce the records, my lord. Because it's only the legal point is involved, my lord.
Mr. Tuanto appears for the petitioner. Mr. S. Thakur appearing for respondent.
1 and 2, my lord.
1 and 2.
Yes, my lord.
Submits that no affidavit is required as the question involved is a legal issue and there is no dispute on facts. He, however, praised liberty of the court to refer to and rely on the relevant records. Mr. Thakur has also pressed into service an order passed by the apex court. Rajara Vishnu Savi reported in 2009-10 SCC 654.
Para 13, madam.
Support his contention that there is a proper partition identifying share of the person who has offered his land and which is offered his land to the respondent, and which land is a party person, which land is a part of contiguous land held by other co-owners.
Yes, sir.
And the share of the Let the previous one. After
After 2 weeks, my lord. In division bench pass an order, my lord, in Mamoni Parak case, my lord.
I don't remember the
Yes,
name.
my lord, Surana and my lord.
I don't
Yes, my lord.
an order.
Yes, my lord. Yes,
In this case, my lord, amended post title was, my lord, directed to be filed, accordingly filed, my lord. And in respect of service of respondent number 5 and 6, my lord, drafty, my lord, was taken, my lord, and to that effect, I have filed an additional affidavit, my lord. Service in respect of respondent number 5 and 6 has been completed, my lord.
5 and 6.
Yes, my lord.
Learned counsel for the petitioner submit that notice was served to the by trustee to the registry of the court and an affidavit of compliance has been filed on 12th of date. It was 23/10/2024. He further submits that the amended post title directed to be filed to the registry has also been filed. Accordingly, let the matter be listed for admission in the month of January. The respondent are at liberty to complete their instructions and file necessary application.
God bless you.
Please, your lordship. Lordship may pass over for the time being as engaged counsel is on legs.
Your lordship,
2 p.m.
your lordship, in this case, your lordship, the private respondent filed the IA for modification of the order, your lordship. So I may be.
2 p.m.
Yes, my lordship. In this case, my instruction is also awaited, lordship. So instead of today, lordship fix another date.
I may be granted camp for filing petition, your lordship, against the IA and reply against the affidavit.
My lord, two.
At 2 p.m.
Hello.
But you have filed an IA for what?
Stay vacating, my lord.
Huh?
It's for stay vacating.
Notice has been issued.
Yes, my lord. It's
Let's see the IA.
no. The notice is not issued, my lord.
Not issued.
Notice is not issued.
Not issued, not issued, my lord.
We'll issue notice here. Let them file their objections if they want. Let them file their objections. Who is their senior?
SP Sharma.
So we'll issue notice. Without hearing the other side, there is no question of vacating the interim order.
Right.
Third, learned counsel for the applicant issue notice. Returnable is the writ petition fixed.
Yes.
Which date?
Just fixed for today.
2 weeks, there may be given.
He listed up returnable in 2 weeks. The respondents are permitted to file their objections with any in the meantime. Let the matter be listed along with the writ petition after 2 weeks. The date to be fixed by the registrar. Who you are appearing for?
I am for the petition, your lordship.
This IA is filed by which respondent?
Respondent number, your lordship, 7.
Seven.
Your lordship, private respondent.
Huh? What if visible?
Yes.
7, your lordship.
7.
Grupul educator.
7.
By respondent 7 is the registrar. And you are appearing for the petitioner.
Your lordship.
And Mr. Kyal is appearing, Mr. Nayak is appearing for?
Yes, I am appearing for respondent number 5, 6, 7 and 8.
PWD?
Yes, including GMC and PWD.
For GMC and PWD. Mr. Borua for Deputy Commissioner and Chief Secretary.
Interim may be continued.
Is it until today?
Your lordship.
Is it until today?
Your
Next returnable date.
returnable date.
Interim order passed earlier. But till the next returnable date, 16th of December.
Much of that.
Lordship, notice were issued to the respondents number 4 and 5. I suppose the service report has not yet arrived, so we need to await for it.
As per office note 2211 with 24, await service report. Interim order passed earlier will continue to the next week. Place on 20 January
Oblige, Lordship.
20.
As per order dated 2010-2024, we have taken steps to the respondents.
My lord, actually land is required under provision of National Heritage 1956. That is why her prayer is that clearly says that, my lord, very simple prayer. Respondent is to release the compensation due to petitioner and other legal heirs of late Bindeswar Dole. There is meaning there, right? There is a dispute among the claimants. It is under the provision of section 3H of National Heritage 1956. This all they have to go to before the competent authority. If competent authority fails to do so, then he has to go for principal court, my lord. There is a provision here. Even we keep on taking instruction after some days again needs to be informed, my lord, because at the provision of law it clearly says once there is a and I think my lord has stated in paragraph that amount also been deposited. If so, I don't know what is the.
No, but you have accepted notice on the last date. You should have pointed out that.
That was pointed out, but notice was issued below what it. It was been pointed out.
No, what is your grievance here that land has been acquired?
Yes.
And
But the proforma respondents, they are not appearing, Lordship.
If so, then they have to go to principal court.
তোমালোকৰ ইনষ্ট্ৰাকশ্যন অলৰেডি কালাৰ ডিচাইড হৈ গৈছে ডিচাইড হৈ গৈছে তোমালোকৰ সেই গোটেইখিনি এনেকৈ যোন আছিলে ন সিহঁতে কিবা এটা ডিক্লেৰেশ্যন দিম বুলি কৈছিলে যে কোনে কাক কিমানখিনি দিব কোৱাণ্টাম সেই বস্তুটো তোমালোকে
what is the stage? I mean, what is the stage of the compensation? Kala.
Already I had my present status I have submitted. So my matter was heard before the Kala. So there the NOK, all the disputes have been settled, and finally they have come to a conclusion that the amount will be disbursed among all the NOKs in equitable proportions, which they will decide accordingly. And subsequently, the amount is presently lying with the Deputy Commissioner because ultimately they didn't submit any proposal as they have claimed stated before the Kala. So that quantum of compensation that is to be shared between all the NOKs have not been submitted before the authority. And accordingly, the Kala is also not in a position to disburse the amount.
You go through this. Some NOK is required to be submitted.
Lordship, before the respondent number 7, the proforma respondents, Lordship, they did not appear on 1/6/2024, Lordship.
Then you get
So the amount cannot be disbursed, Lordship. They are not appearing, the proforma respondents.
how do we compel them to appear?
The government
How can we compel them to appear before that authority?
And half
You can
payment.
change, you can make applications to change this order if you want.
Yes, sir.
You go to the, there is a provision here.
If someone appears, but you will be there.
Heard counsel for the petitioner, that's for the court.
With arbitration.
That's the-
Arbitration का amount लोग पे नजर principal
The
notice दो.
respondent authorities have not released a compensation due to the petitioner and other legal heirs of late Ritesh Dole, who was the owner of the land, was acquired by the respondent for the purposes of construction of national highway by the National Highway Interest, NHIDCL. The last date notice was issued making it returnable today. There are today Mr. S. Purwal and a counsel appearing for the district commissioner has placed before the court that the competent authority, namely the Kala for the district of Dhemaji, had heard the issue concerning the petitioner and other heirs. And the matter was heard on 29/2/2024, and it was decided that the fresh next of kin of late Bitweswar Dole would be submitted, and the matter would be settled amicably amongst the next of kin. And accordingly, the Kala passed an interim order to that effect. On 13/5/2024, a new next of kin certificate was produced before the Kala, Kala, wherein the three names, namely Hitesh Dole, Konto Dole, and Priya Begu, were included, in addition to the earlier two names, namely Manonti Dole and Vijoya Dole Begu. Stop. Based on these next of kin certificate as well as the earlier order, the matter was disposed of on 1/6/2024. Stop. However, the next of kin of late Viteswar Dole, in terms of the order passed by the Kala, did not submit any proposal or representation regarding the quantum of compensation to be received by each of them, or in whatever way it may be uh, dispersed. As such, except for one of the next of kin, namely Sri Hitesh Begu, claiming the compensation in favor, no other communication has been received, and therefore the concerned office of the Kala is not in a position to disperse the same. Para, having noted the instructions placed before the court, and upon due consideration of the submission of the petitioner, what appears is that the disputes with regard to distribution of compensation between the petitioner and the pro forma respondent appear to have not been resolved amicably. If that be so, then the provisions of National Highway Act 1956 lays down a prescribed procedure for claim and distribution of the compensation amount, which has to be decided by the competent authority and the other prescribed forums under the same act. Accordingly, this writ petition is disposed of with the direction Where is the order, 29-2? No, sorry, 1/6/2024? Accordingly, we direct the office of the district commissioner, Dhemaji, to place before the court the order dated 29/2/2024 and 1/6/2024, stated to have been passed by the color. On the next date fixed. If they are not settling it,
Then they have to go to under 385.
where is 3H5?
There is there. Or competent authority. If they are not satisfied, they have to go to
Competent authority was required to decide on the
Decide.
compensation.
decide.
It did not
Suppose
decide.
Suppose Milord cannot.
No, it did not decide. It left it to the claimant to arrive at a amicable solution and decide.
I only submission what is that my provision I am saying, Milord.
No, you're right, but there is no provision. The provision is that the competent authority will decide.
Decide.
They did not decide.
They didn't.
And they closed the matter.
That is up to competent authority what matter it will be decided.
But they did not decide.
But according to them, the power of correspondence is not appeared. That is because of that.
Whatever it may be, but it did not decide. It says it left it to the parties to say amicably settle, and the matter was closed.
Lordship, I have the electronic version of the order that your Lordship has referred to 29.2. May I read it out? The synopsis of the case is that with regard to the compensation of the acquisition land in number 1 Torajan covered by dock number so and so, which is recorded in the name of Bideswar Dole, Jonai has submitted proposal along with the required document for compensation to Mrs. Minoti Dole, to which a complaint has been lodged by Hitesh Dole to the effect that his name has not been included in the NOK list, Bideswar Dole. The matter is taken up for hearing today. Both the parties were present along with the LRA and Gaon Pradhan. In the hearing, the party apprised that they have decided to settle the matter amicably, which is allowed provided a fresh NOK certificate is submitted to the undersigned for disposal of the matter. With this, the matter stands disposed of.
This is on.
This is the 29th of February 2024.
And what order was passed on 1/6?
1/6. Yes. The matter was heard on 29/2/2024, wherein the parties decided to solve an issue amicably, provided a new NOK of the Bideswar Dole Patadar is submitted to this office. A fresh NOK bearing certificate number so and so and application number so and so, Bideswar Dole is submitted. After perusal of the claim made by Sri Hitesh Pegu to be the grandson of Bideswar Dole, the two grandson and granddaughter, namely Sri Bosanto Pegu and Priya Pegu, the names have also been listed in the NOK of Bideswar Dole. Hence, the NOK certificate submitted earlier to this office bearing number so and so and application number so and so, this is found to be incomplete and not correct, stands invalid. In the light of the above, it is concluded that all the 5 NOKs, Bideswar, whose name are given in the NOK bearing certificate numbers, this one, and application number so and so, Bideswar Dole are eligible for the compensation sanction in favor of Bideswar Dole. Office to be sent concerned with the matter stands disposed of.
That is what I'm saying. The Act provides for them to determine the compensation.
Yeah.
It is not determined. Where is the determination? Where is the determination? Where is the apportionment? In these two orders, there is no apportionment.
That is the crux here.
No, that is to be decided by the competent authority. Competent authority did not decide.
Lordship is correct, Milord. whatever manner it is to be decided. Whatever manner it is to be decided by competent authority. If they are not satisfied, then only further can go. Competent authority to decide it. Competent authority left for amicable settlement. No. Lordship is in this regard. Lordship is directly it is interpreted because he has to decide manner what he will decide. If he agrees, they will go. But competent authority is leaving to parties go for amicable settlement. That is also lordship.
No,
Because here
from what I can make out from this set of instruction is that already in the hearing amicably they have decided that the apportionment is will.
You're not understanding the issue. The amount is deposited with the Kala.
Kala.
The Kala has to decide. Kala cannot sit over the compensation.
No.
Kala has to distribute the amount. Before distribution, it has to decide who will get what portion.
Yeah.
If the complainant, if the claimants have not been able to decide or give their suggestion, then it is left to the Kala to decide or reject their claim. They cannot say that you decide amicably, we are closing the matter. And he's sitting over the claim. How is he doing it?
No, now what it reflects is that ultimately they
you read the provisions of the act.
I have gone. Yes, the Kala ought to have decided, but finally, what has been transpiring from this instruction is that they have stated because ultimately, amicably, they have
stated anything, but the responsibility is on the Kala.
That's
He cannot be absolved. He
That's
cannot
not-
be absolved by saying we'll take 10 years to decide. Cannot be.
Lordship, the pro forma respondents did not appear before the additional deputy commissioner Dhemazi. If they would have come and amicably settled none of the
For the Kala to decide. Huh?
Wait.
You place these orders on record.
Yes, yes.
Bring it on record.
Yes.
But I am in 156.
I think Perut, the orders of the produced instruct place before the court and after getting out to the view. That the orders dated 29/2/2024, 1/6/2024, passed by the competent authority. It's this matter be placed for the court by the respondent representing the state and the representing the respondent number 3, 4, 3 and 4. Further order is required to be passed on the next day. This on 16 December. Mr. D. Purva appears for
1, 5 and 6.
1, 5 and 6. And MS PR Monto for Mr. Purva for 3 and 4.
Lordship, in item number 36, there is an interim order. I was not aware of.
Which 36?
This is 40.
WBC 4369.
No, this is no way to mention. We have passed an order.
Lord, I was not aware of.
You are not aware what can be done. You can't just barge inside.
My Lord, I apologize for that.
Well, the matter has been taken without any reference. Item so and so, some interim order is
I
passed.
apologize, my Lord.
We don't know. We'll check up. You come back at 2 o'clock and make a proper mention. Some interim order.
Yes. Lord, the order was passed on 38/2024.
Interim order passed. Yes.
My lord, in this case, my lord, the petitioner has been referred by the SP Corpita to fight reference case number 002 of 2024. After my lord making a press entry.
You've been referred, you go and appear.
Yes, it is pending before the my lord Borpeta Foreigners Tribunal number
notice issued?
7. No, probably notice is not issued. This is from the SP concerned matter. It is sent only on 19/10/2024.
1910.
Yes, ma'am. Her statement is recorded in there. Probably for that purpose, the police visited to her place. Probably for that purpose, she is coming.
You find out whether notice has been issued.
Notice, my lord, probably notice, they will get notice by within short period, because it is sent to the my lord Foreigners Tribunal number 8.
Very well, then. We
My
close
lord,
the
in
matter.
that case, my lord, matter may be adjourned. Let the case registered and notice issued. Thereafter, otherwise, what will happen, my
We'll
lord?
get it on Monday.
Again,
No
police
issue. I
will
can
go-
I can get
Friday. Friday?
Friday.
Let it be on Friday. Let us see what is
Yes. I will get from the my lord Foreigners Tribunal number 8. Yes.
If reference is ready, it will refer to the tribunal, my lord.
Already referred.
Already
Referred to the tribunal.
Yes.
It is pending before the tribunal.
You get us whether
Yes.
notice issued.
Then
or not.
if notice is no reference case number is there. I will get the FT case number if registered. Yes.
After reference, FT case number will be there. If that
I
is
will get
given, that will.
I can set by Friday.
Place the matter on Friday, on which day the Standing Council for the State will find mail apprise the court the status of the reference if any made by the SP order Borbetta. The concerned court.
Reference is met, madam.
Registration of the reference by the concerned foreigners tribunal of the reference. Is there a reference number?
Yes, madam. Reference case number 02 of 2024.
02
Borbetta.
2024.
Borbetta.
Referred by the SP order Borbetta. Based on Friday.
Yes. Correct.
Mr. MSI, appears on the
May I please, your lordship? My lord, here petitioner's father lordship, along with his two brothers lordship, purchased a total plot of land of 4 biga 4 lechas lordship, out of which 1 biga lordship is 1 biga 2 kata is action of land lordship in the year 1952 lordship. Now lordship, after the death of his father lordship, petitioner possessing lordship 4 katas of land lordship, and also paying the regularly revenue lordship to the government lord.
Have you applied for settlement?
Lordship, I have already approached the authorities, lord.
Where is that?
Lordship, although I have not annexed that application, lordship,
Then?
but so far as my instruction, lordship, they have approached, lordship.
What do you want from the court?
Lordship, now, lordship, the authorities, lordship, trying to evict me, lordship, with for settlement of other evicted persons.
Therefore, we want to know whether you have applied for settlement of that court.
Yes, lordship. Lordship, I will, lordship, pursue the matter, lordship. In the meantime, lordship, and lordship, at least no coercive action shall be taken against me, lord.
Not like this. You are entitled to withdraw it, or you are entitled to. We can issue a direction.
Lordship,
If you have produced a copy of the representation, you should have directed.
I have no such instruction. So at the lordship, this scenario, lordship, your lordship may allow me to approach the authorities by filing appropriate application, lordship, and they will consider it as per law, lordship.
They have to
Then you have to withdraw the petition.
Lordship, I may be allowed with the liberty to approach the authority.
Mr. The Council for Revenue Appeals.
Lordship. I put a revenue, lordship. That's one number.
As well as Council for the State Council appearing for responsibility. The petitioner submits that he approached this court seeking a direction to the respondent authority to settle the land under his possession and occupation, which he claims he had inherited from his father, late Abdullah, along with his two brothers, namely the petitioner's uncle. It is the submission of the petitioner that there is an apprehension that the petitioner may be evicted from the state land claims have not been redressed. And the petition counsel for the petitioner has not been in place. Any such representation or application seeking settlement of the land in question before the court. After submitting for some time, the council seeks to withdraw its petition and say for the permitted dismissed or withdrawal. Petitioner is permitted to approach the authorities and file necessary applications as per provision of law.
My lord,
Petition dismissed or withdrawal. Yes.
my lord, till decision in my application.
It is a totally government
Petition is
land.
dismissed for
Lord, no.
withdrawal.
Because otherwise, lordship, in the meantime, anything may happen.
Therefore, we asked you for that application which is not there.
Lordship, then lordship, your lordship may fix it on Friday, lordship. I will pursue the matter whether any such application was filed or not.
If it is filed, filed. If it is not filed, not filed. If you don't have instructions, why do you appear in court? Get your instructions properly. Once the order is dictated, now you want the court to recall that order.
No.
Right? You go and approach the court. We're giving you liberty. Approach the authority.
Yeah. And subsequently, I may also approach if required.
We are not stopping you. Nobody can stop you.
All right. All right.
Engaged counsel is out of station, lordship.
The respondent number 2, 3, and 4 and 5 has filed an affidavit in opposition, stating therein that grievance of the petitioner has been satisfied in para 3, my lord.
When is the council back?
After 2 weeks.
It's after
My
2
lord,
weeks.
he is continuing. Now his grievance already satisfied.
There is some interim order.
Yeah.
Is there
No
any-
interim order, my lord.
Huh?
One is that he was given liberty to participate in the concern.
There is an interim order.
He participated and accepted and rebated his application was considered and 3, my lord. 3,
You
my
get
lord.
instructions. We are listing it next week. Next week.
After 2 weeks, lordship, make it. After 2 weeks.
He says there is an interim order.
Okay.
Not in interim. He already participated.
But there is an interim order reflected.
Well, there are 3, my lord, of my affidavit. There are 3, my lord.
There appears to be an interim order here. Status quo with regard to shop number 15.
15, my lord.
What has happened now?
He is continuing.
You
His
have passed
business
some order in his favor.
in his favor. I have stated in my affidavit, my lord, and he is paying 3,850 rupees per month.
Paragraph.
Paragraph 3, my lord,
Paragraph 3.
page 59.
All right, you get instructions on next Wednesday.
Lord.
List on 4th.
Lordship.
4th December.
Obliged.
At the request of
Due to some extreme emergency, my senior had to leave to court premises.
When is he coming back?
Lordship, on Monday.
Monday. Uh, let it be on, all right, Monday, second. At the request of council appearing for the matters has deferred to be listed on Monday. This is 42 and 43.
42 and 43.
Okay. Mr. Parvez appears for
4 to 8.
4 to 8. And Mr.
In
Das,
item number 1 to 3, item number 42. And in item number 43 for 1 to 5.
item 48, 4 to
1 to 5.
No, in the earlier matter,
4 to 8.
4 to 8. All right, Monday.
And affidavit is already filed.
Monday.
Like.
May I please go? As per order 28 and 24, government is supposed to file a reply.
Affidavit.
Affidavit.
Lordship, affidavit is ready, Lordship, we'll file it.
But it is the
The partners in non-payment of house rent.
the liberty is granted to the petitioner to file reply affidavit.
No, we have filed our reply. After that, on 28 and 24.
28?
10, 20. What is giving direction to the government, whether the.
Do you have the copy of that order?
No.
You have the copy of that order?
No. Because on last occasion they have submitted, they have received some instruction regarding the payment.
Not recorded here. You want to file some affidavit?
Lordship, we'll ready, Lordship, we'll file it. We'll file it, Lordship, in 1 week.
2 weeks further time granted to the state respondent.
Lordship.
File their affidavit as prayed for. Mr. Chetri appears for
the
petitioner.
My lord, I'm appearing for response number 4.
You are Mr.
S. Hazarika.
S. Hazarika for respondent. Please, after 2 weeks.
Obliged.
May it please your lordship. Petitioner's husband, my lord, he was expired in the custody of the state, my lord.
Yeah.
And there was particularly, my lord, respondent number 3 and 4, my lord. There is gross negligence on their part, my lord. And he was not addressed the proper treatment, my lord.
No, we'll file affidavit, Lordship.
Huh?
I have, my lord, filed reply also on 8/8/2024.
You have filed your affidavit?
Lordship.
What is your stand here?
He's in the jail hospital, Lord. In the hospital, jail hospital, Lord.
Where are the reports?
Hospital, jail, Lord.
Postmortem report, etc.
Annexure 10, my lord, page 28, running page 28. That was due to pulmonary tuberculosis.
Where is it stated? Where is it stated?
What's it?
Cause of death?
Cause of death, my lord, pulmonary tuberculosis, my lord, Annexure 10, page 28, running page 28. They in their affidavit, my lord. And my lord, Human Rights Commission, my lord, closed my lord case.
Right.
Because, my lord, they have stated
Page 32, Lord.
Huh?
Page 32 of our affidavit, Lord.
We want to see the cause of death. Postmortem report. No postmortem report.
My lord, postmortem report I have annexed, but that time, my lord, postmortem report was pending because that was, my lord.
Psychology.
Yes, my lord. Toxicology report were not available at that point of time.
Where is that page number?
Page number, my lord, 54 in the writ petition, my lord.
Pending, Mr. Counsel. Come to page 54.
Subsequently, our affidavit lawsuit, page 7 lawsuit, page 7 of our affidavit lawsuit.
See, when you want the matter to be heard and the pleadings are exchanged, there has to be a continuous paging. It's not page number so-and-so of petition, page number so-and-so of affidavit. You refer to a continuous paging. That is done by the registry, but as counsel, you must bring it to the notice that it requires continuous paging. Otherwise, it's difficult to go through. Page number
In our affidavit, page 7.
7.
Page number.
Yes.
Page 30 lawsuit.
Hmm?
In the 30, there is a postmortem report in page 30 lawsuit. Upon affidavit. Death was due to pulmonary tuberculosis, in bracket natural death loss.
Page 3030.
30. Uh,
30 is the same copy. Opinion is kept pending.
My lord, page number is not, my lord, similar to my.
20.
Yeah.
Yes, which page?
In my petition, it is 30 lawsuit.
You
Is 85.
So why is it written Human Rights Commission?
They approach, sir. They approach.
But don't you have your original document? This is a copy of from your procured from the Human Rights Commission. There has to be a complete report given by the Department of Forensics. Hmm. So what is the cause of death? Pulmonary tuberculosis.
Lawsuit. In bracket natural death loss.
How can pulmonary tuberculosis be natural death?
And my lord, there were several orders, my lord, passed by the honorable court to give proper medical treatment to the petitioner. And my lord, a petitioner husband, my lord. And petitioner have repeatedly asked the jail authorities to.
Where are the medical documents of this person? In the jail, there must be a file. Where is that file? Get that file.
Yes.
All medical records maintained by the jail authority.
Yes.
What was the order passed by the human rights?
From 86, my lord. 29/10/2019, my lord. In their affidavit, respondent affidavit.
Our turn comes in parties. The pleadings are complete in the matter. The petitioner is before the court paying, seeking a direction to cause a judicial inquiry or an inquiry by an independent agency like the CBI in to inquire into the incident of unprecedented and untimely death of the petitioner's husband in the central jail of Guwahati. So, petitioner's husband was taken into custody pending investigation of Bureau of Investigation within bracket Economic Offence Police Station case number 11 of 2019. In spite of complaints made by the petitioner's husband to the superintendent of Central Jail and the medical officer regarding the various physical discomforts he was suffering because of health issues, proper care and treatment was not afforded. And consequently, the petitioner expired on 2/8/2019, a morning hour. Stopping the claim of the petitioner that her husband expired due to lack of proper medical treatment. And this was deliberately done to keep under wraps a mischief committed by some unknown person leading to the death of the petitioner's husband. So, at the time when the writ petition was filed, the postmortem report was conducted. The opinion was not issued by the Department of Forensic, as the toxicology report was awaited. subsequently affidavit has been filed showing that the death of the person occurred due to pulmonary tuberculosis within bracket natural death. The respondent have filed an affidavit enclosing postmortem report and the toxicology report. However, along with other along with some other documents, along with other annexes, but the medical record maintained in respect of the petitioner in the jail hospital not reflected, nor is faithful. In order to understand the ailment or the treatment which was offered to the petitioner, the relevant medical records maintained by the jail authorities be necessary. The respondent number 3 is therefore directed to place the medical records 3 and 4 directed to place the medical records maintained by the jail hospital in respect of the petitioner husband before the court within a period of 2 weeks from today. Let these records be placed if required by way of an affidavit by the court. This report.
Of life.
Yes.
Here there are the dispute with the petitioners by section of respondents. But if I will draw your kind attention at page, my lord, 47. First, I will draw your lordship kind attention at page 34, my lord, 34. 34.
Yeah.
The deputy commissioner, my lord, has made an ad hoc committee. I may read, my lord. Sir, I would like to inform you that on 27/12/19, a meeting was held in the office of the DC, accordingly constituted an ad hoc committee of 10 members till the election of the member of the general meeting. For that reason, following a person were recommended, namely so and so and so. Now, lordship, last sentence. This new ad hoc committee will take place on 22/20 till the election of Sri Askila Namgar in the month of Bhar. Now, lordship, we are the committee, and still we are the committee. Now, lordship, when this was issued by the DC, what happened at page 47? 47, man.
Yeah.
Well, kindly see, this letter was issued by respondent number 6 to the President Secretary. We are the President Secretary, my lord. Sri Askila Namgar. Invitation letter to attend the annual general meeting as per address of the Barbaric to be held on 25/12/21. He has issued a letter to us that we are going to hold a meeting. Who is he? So we challenge this. My lord, now the order, the Honorable High Court heard the matter at page, my lord, page number 60.
Page number?
Page 60, my lord, 60. And it's a 14 minutes. Lordship, both we were the petitioners and the respondent, private respondents are here, and the who has issued the letter, he is the respondent number 6, my lord. Now, finally, see the matter order of the High Court. Page 63, my lord. Heard Mr. Suikia, learned counsel for the petitioners. Also heard Mr. S. Sharma, learned government advocate. Assam appearing for the respondent number 1 to 5. Mr. A. Ahmed, learned counsel, has appeared for the private respondents number 6 to 16. The two petitioners hearing claim to be the president and secretary to the CC Askila Namgar committee. Being agreed by the order dated 3/11/21 issued by the respondent number 5, postponing the holding of the meeting, annual meeting of the Namgarh Pariषद Committee fixed on 6/11/21 on the ground of outbreak of pandemic COVID-19. The present petition has been filed. Mr. Ahmed submits that now that the pandemic situation has subsided and it is possible to hold the AGM election of the Petitioner Committee, hence the petition be disposed of by permitting the holding of the AGM general meeting of the committee. The respondent has agreed. Now Mr. Soikal, Learned Counsel for the petitioner, has also agreed to the said recourse, but submits that all actions in the matter must be initiated strictly in accordance with the bylaws of the committee. Mr. Sharma, Learned Government Advocate, Assam, has also submitted that the petition can now be disposed of by permitting the holding of the AGM elections of the committee. In view of the stand taken by learned counsels for all the sides, without commenting on the merits of the claim and counterclaim of the petitioners as projected through the pleadings, this petition is hereby disposed of by directing the President and Secretary of the CC Achkela Namgarh Committee to convene the general meeting of the Namgarh Petitioner Committee by circulating proper notice and by following the due process laid down in the bylaws. The exercise be carried out and completed within a period of 6 weeks from the date of receipt of the certificate of the order. The respondent number 5225 to render necessary cooperation in holding the AGM election of the committee in a manner permissible under the law. With the above observation, the petition stands disposed of. So after this order, my lord, we have held a meeting. Lordship will kindly see. The meeting is, I have notice or issued. I have annexed some of the page 66 to the Barbary. Yes.
Yeah.
The Circle Officer, the Deputy Commissioner had also, my lord, in his order stated that the meeting has been held on 9/9/22. He has issued accordingly an order. And Lordship, when he has issued the order at page my lord, 80, page 80, it is to be informed by that the Honorable High Court direction
So
of
anyway,
order.
that meeting was held.
Held.
Then what happened?
Then they locked the door, the main door. And again we have come by filing another petition. Then they opened the lock. But inside there was one office.
They locked the door with you inside.
From outside.
From what?
So then when the lock was opened, the direction was issued by the Honorable High Court in another petition I have here, that if you do not open the lock, do not open it for all. A section should not be given any benefit. All should be allowed. Then what happened was there is an office inside the premises, and that office lock was not open. That's why, my lord, they made a prayer before the court that the meeting which was held, it was not as according to the bylaws. My lord, the inquiry was conducted by the DC, and we came that DC was the respondent. So we made the statement that another independent person should be allowed to make an inquiry. So the inquiry was conducted by the private principal secretary, and in the inquiry he has made the inquiry not as per the amended bylaws, but as per the 2004 bylaws. Then we filed the affidavit, my lord, to that inquiry, that the inquiry held.
What is this order that you are praying for setting aside? Page Annexure 21.
Just a minute, madam. Yes, my lord. Annexure 21, my lord. This that latter part in page 80, The latter part now considering the prevailing law and order situation and to maintain peace and tranquility in the Namgar premises and in district, the date of takeover and handover of the charge of the police committee may be postponed. This part was challenged. First part was, we have not challenged because the first part they have admitted that we have held a meeting as per the order by the High Court. This second part, when it was issued by the district magistrate, we have challenged, and this is the present petition.
You have been elected to be.
Yes, yes, we are
committee to
elected,
take over.
President, Secretary. New committee elected.
And till date, it has not been handed over.
And they did not, whatever, they did not hand over the key of the inside the office.
What is the position today?
Today, my lord, the position remained as it is because we are not allowed to.
There is no title suit.
Now, title suit, my lord, the court has held that the Corner Dhara committee, they said we are the Corner Dhara committee. Court held that there is no Corner Dhara committee, time has expired. So the purpose of filing the injunction petition became infectious. We filed the injunction petition that the Corner Dhara committee against the Corner Dhara committee, and when the period is 6 months for Corner Dhara committee, illegal, that was also illegal. Then the court held that it is 6 months is already lapsed. So it becomes infectious. There is no Corner Dhara committee now. I have brought the certificate copy, my lord.
Yes, who's for the respondent here?
I'm appearing for the respondent, private respondent, 6 to 16.
Who's for the district magistrate? Golaghat. Why have you not handed over in charge of the committee pursuant to the meeting?
We were actually not a made party in this matter. I'm applying for the GAT matter. As for order dated by Lord 53, as for order dated by Lord in terms of order date 25, 9, 23, and 21 to 24, we were basically asked to hold an inquiry, my lord. Accordingly, my lord, in compliance of that particular those two orders, we held an inquiry and we filed an additional affidavit, my lord.
First, take us to
First of May, madam.
first take us to the orders pursuant to which you conducted the inquiry. Where is that
Will
order?
come to the will directly come to the additional affidavit which we have filed. Dated 11/5/2024. I can see additional affidavit with WPC 6.7
Gopul Lekharu.
Yes, sir. My lord, in accordance to the paragraph 3, my lord, the answering deference states that as for order dated 20.
We want to see that order. Where is that order?
It's in Annex 1, my lord.
25/9.
Page 88. Internal page 88. Relevant portion, my lord, is 91. On order, my lord, this is third district also, my lord. By inviting the attention of the court, the order is passed by in IS the court has directed the divisional commission to conduct an inquiry on the issue raised by the petitioner applicant thereafter submit a report. Saluda submits that the post of divisional commissioners has since been acknowledged and present the principal secretary to the governor of DAD with the authority studying the functions of the divisional commissioner. As such, the court permits the inquiry as directed by the order dated 21/23 can now be conducted by the principal secretary to the governor of DAD. Governor counsel for both the parties contesting the parties have submitted that they would have no objection if the order dated 21/23 is modified to the above extent. In view of the above, the principal secretary of DAD is hereby directed to conduct an inquiry in terms of the earlier order dated 21/23 passed by the Honorable Court and thereafter submit a report. The aforesaid authority may issue notice to the rival parties intimating them about the date of appearances so as to enable them to submit their versions along with the supporting documents. The report be prepared after taking into account the facts and circumstances as well as the documents produced by all the interested parties, including the contesting parties therein. Report as called for be presented on or before the next date. Thereafter, my lord, after the next order.
Where is the report?
It's there, it connects them, no? After that, my lord, in page 99 is the again the next order when the matter was listed on 21/3.
What is the date of the order? Date of the report?
The report is, my lord, right after that, sir.
is 14th March 24. Your Lordship, please, just before Your Lordship comes to page 99, of the there, my Lord, again the second order is given. Lord,
There is no internal page, there is only one page.
Page 99.
There is no 99 here. We have continuous pagination. You are referring to the additional affidavit.
Filed by the. There, my Lord, the 21C order also is affected in terms of the court order dated 25
Right. First order is annexure 1, then 2,
Then
and
two
the
says,
report
my Lord, two says that the
report is dated which date?
report is my Lord 14th of 20. Report is 22nd February. 22nd February. And
Is it annexure 3?
no, it's annexure 3. Annexure 3. The relevant portion starts from page 103. That is inquiry report on the management committee election of India Namkar. Hearing date 2/1/2024. Venue conference hall of the circuit hall Sulaka. And that is the whole thing. There, background. On the last occasion, both especially the petitioner side had taken time, even the my Lord, because some sort of development was there. They had taken time. So, my Lord, since it's come today, my Lord, we fix it for hearing, my Lord, on some date, my Lord.
No, my Lord, that is time has gone because they wanted to reconcile the matter. They demanded the post of the assistant secretary. We offered them. Then they came up that,
we don't know, my Lord.
then they came up that okay, they have come back that general secretary post should be given. How that we differ because
So
assistant.
what do you say to the
Report.
page number 3 of the report?
Yes, my Lord. Kindly see, my Lord, at page. No, yes.
105.
Page
Relevant.
finding, my Lord, 105. 105.
Yes.
Finding of the inquiry after observing all the materials available, evidences analyzing the sequence of events, recording the statements and scrutinizing the process of the bylaw of 2004. It is not applicable because bylaw is 2019. That is their malafidiness. Lordship, we have filed the affidavit. And this is the bylaws where they were present. In 2019, the bylaws were, my Lord. Yes, you are the bylaw, my Lord, of 2019. We are annexed in the repetition also. Yes, this is the bylaw. My Lord, this is the bylaw of 2019. And their members were present. While these bylaws were, my Lord, passed in 2019, they themselves were present. My Lord.
What is the procedure for acceptance of the bylaw?
Bylaw term is bylaw of the holding the AGM by the general meeting, in the general meeting. And there the term is 5 years. In 2004 term was 3 years. And there were some laws were amended, and as per the amended laws, we held a meeting. And in the meeting, they did not come up with faculty for vacating the order of the High Court. They filed a review petition.
The earlier bylaws were there.
Yes.
During your tenure, you changed the bylaw.
They were also with us. It was
Is
changed.
there a resolution that the bylaw is adopted?
Yes, bylaw 2019.
Where is that resolution?
My Lord, this is the bylaw, my Lord. They were present.
Resolution adopting this new bylaw.
Oh, resolution, yes. Resolution is, I have annexed in the writ petition, my Lord. Resolution also is there, Lordship. Just I am showing the booklet.
Where is that resolution?
My Lord, this is the booklet.
Who was the resolution first?
My Lord, my Lord. No, writ petition, the writ petition. Resolution is in the book itself, my Lord. In the booklet.
Huh?
In this bylaws itself, resolution was taken. Resolution is there, my Lord, in the booklet. In the bylaws itself.
No, who is in charge of the, under whose custody is this proceeding book?
No, we are the petitioner committee, but they disturb us because they
Under whose possession is the proceeding book?
They did not open the lock now.
It is on the district administration.
They did not open the. They did not open this that small room. all the books are kept and all the ornaments are kept in amounting rupees, amounting heavy amount, that did not open the office.
So was the bylaw, so was the bylaw.
Bylaw, that is the bylaw, and I have annexed it
Not
also.
bylaw, the
In the
resolution.
petition, I have annexed it.
Resolution adopting the new bylaws.
It is not there, Lordship.
No, in the booklet is there, man. I will show it, my lord.
Your booklet is not a
Booklet
part
is
of the
immediately
pleading.
prepared, Lordship.
Is it a part of the pleading?
Yes.
No, Lordship.
Yes, reading. We have mentioned it in the petition.
So is this booklet a part of the pleading?
That
Have you
book-
brought it by way of an affidavit, writ petition?
Yes, yes, I have mentioned this about this, my lord, booklet, about this amended laws.
So you have mentioned, but who has amended this?
My lord.
You have brought this
No, that
bylaw.
this was amended by both the parties.
Where is that amendment resolution?
Amendment resolution, my lord, I will show in there itself is there.
Where?
In this
This
amended
booklet
bylaw.
is not a part of the pleading.
No, my lord, we are,
After all the pleadings are exchanged,
no, just a minute, my lord. The pleading that I have made also that pleading, I remember.
let the matter be listed for, this is for admission now.
Yes, Lordship.
Let the matter be listed for admission hearing.
A short date may be given because they did not allow us to enter the Namgar.
January,
No, my lord, in the month of first week of December, second week of December, my lord, kindly. Because they stop it. 1,800 Fakots are not allowed to enter the Namgar with the help of the Deputy Commissioner. Because the whole story is that 5 crores rupees were sanctioned by the Chief Minister and they wanted that money and we have to file the affidavit that money is not necessary for us.
These are unnecessary.
No, we have filed the affidavit and they have pleaded in their own case, on their affidavit.
On the last occasion, it was the petitioner who took time.
Let it be heard, my lord, in second week of December, my lord, kindly.
second week we have, we don't know whether we can hear it. Let it be heard in January.
Yes,
My lord, my lord, my lord, in the meantime,
let them bring the.
no, my lord, in the meantime, we should be allowed to enter to the Namgar.
That is the issue to be decided.
No,
Who will enter.
there are two issues. Number one is opening the lock.
See, the report of the district administration is that the meeting was not conducted as per the earlier bylaws. According to you, earlier bylaws is gone, new bylaws are there. You show us from a resolution adopted as per the rules that this bylaw is the new bylaw.
My lord, I will read it at night. I'll place it day after tomorrow.
No,
This resolution, I place it before Lordship. Yes.
Let them bring it on the.
Because there are 3 number of affidavit. And in one of the affidavit, we have pleaded that. Let it be, my lord, how day after tomorrow, I will place it that resolution was taken.
We'll keep it on 11. You show us 11th December.
My lord, oblige me.
We are returning you your booklet. You can take it back.
My lord.
Matter be listed again on 11 December. The counsel for the petitioner will place before the court the resolution adopted to accept the new bylaws.
Yes.
i.e. the bylaws of 2019.
19.
In place of the earlier bylaws
2004.
of 2004.
4.
So, matter be listed accordingly. Mr.
DJ Kapil, Lordship.
DJ Kapil appears for
Respondent number 6 to 16, Lordship.
6 to 16. Mr.
A. Fukan, my lord, actually our name has not been.
A.
for the
Fukan
general administration.
has appeared on behalf of the GAD department, who conducted the inquiry as per the directions of the court, and an affidavit has been filed to bring the inquiry report on record. Mr. A. Goswami for
And we have replied to their
1 to 5.
and we have replied to their affidavit also. My lord.
It's on 11.
Oblige me.
Lordship, this
case pertains to Lordship, notice was issued for Lordship, proclamation of sale Lordship of the key state address petitioner, and we have challenged that notification. I will Lordship find notification of page 50.
What are you challenging?
Lordship, the notification was setting for sale proclamation Lordship at page 50 Lordship. Some Lordship, amount was the PF of this employees or GI Lordship, and this petitioner defaulted to pay this amount.
Yes, then
And Lordship, accordingly, they have issued a certificate, and accordingly, Lordship, for exhibition of the certificate, setting a sale proclamation was issued by 14/7/23, and that notification is in challenge, Lordship.
Hmm.
Because Lordship, this notification doesn't indicate Lordship which area of land they are going to Lordship sell, and the amount against which Lordship they are Lordship intending to sell proclamation. So nothing was there. We have challenged that notification.
who's for the respondents here?
Respondent Lordship. Respondent earlier Lordship they are paying that.
Name or not?
Provident Fund.
Loss.
Who's for the Labor Department?
Earlier Lordship senior concept NC Dastar was there. Lordship. The second Lordship, we are ready to
Names
pay.
are not reflected?
Yes.
The council?
Yes.
Huh?
Yes, not reflected.
Oh. Respondent names are not reflected.
20.
Third, Mr. J. Kodikar. None appears for the respondent. One is the Provident Fund Commissioner of the Assam Tea Employees Provident Fund Organization. Although an affidavit has been filed on their behalf. The both is, however, does not affect the name of the respondent. Accordingly, matter be listed next week, reflecting the name of all council.
Can be affected.
2 weeks. Thereafter, 2 weeks. Then it goes to the month of January.
Lodge.
Let it be listed in the third week of January. After reflecting the names of all council.
Lodge. All right.
In this case, Lordship, my house was taken on rent by the PWD and Lordship. The Lordship, may kindly see order dated 8/5. Lordship. We have already submitted our application. Respondent number 5, Executive Engineer PWD Silchar, Lordship, filed his affidavit in opposition. And in the affidavit in opposition, Annexure 3, page 41 is there, Lordship. There is a process of refixing the building rent with effect from 2015. Lordship.
The payment has already been made.
Lordship, that was not the enhanced amount for the last 4 years. Lordship. since 2015 to the till the vacation November 2019, Lordship.
Where, how have you announced it? By agreement?
Yes, Lordship. It is an admitted case, Lordship. They have already, I have annexed some documents, Annexure 4, page 20.
Annexure 4 is the SS rent is 4412.
Yes, Lordship. Thereafter, it was enhanced, page 22, Annexure 5. Page 23, relevant portion, Lordship, last paragraph.
6618.
Yes, Lordship. And thereafter, it was not enhanced. And in their affidavit also, they have stated
And what is the provision for enhancement?
Assam Land Revenue, Lordship, that was as per Assam Land Revenue Act, they have reassessed that amount. It is reflected in page 23 itself.
So what is the procedure for enhancement?
Lordship, Assam Urban Areas Rent Control Act. Areas Rent Control Act 1972. Section 3, rent, Lord, fair rent.
Section
3, Lord. My new book, page 692.
Yes.
Subject to the provisions of this act and notwithstanding any contract to the contrary, no landlord shall be entitled to charge rent for any house at a figure higher than the standard rent if at any time after 5 years from the date on which a house is in continuous occupation of a tenant, the market price of the land and estimated cost of construction of the house increases by more than 25% on the basis of the value of land and cost of construction of the house on the date of preceding fixation of fair rent, then the landlord shall be entitled to have monthly rent increased by an amount not exceeding 1/12 of the 7.5% of the increase in the market price of land and cost of construction on the date of preceding fixation of fair rent from the date as may be prescribed, subject to a maximum of 50% of the preceding standard rate, provided that subsequently after lapse of every 5 years of the revision of fair. So there is a procedure, Lordship, every 5 years it has to be increased, reassessed. So accordingly, Lordship, page 22 itself says, this is to certify that the monthly fair refixed rent of the Assam Tribe building belongs to Sri Shihabuddin Ahmed of Abdul Rauf Chaudhary Road, Ward number 1, Karimganj, and hired for the office accommodation of the Assistant Executive Engineer PWD AACP Subdivision Karimganj is reassessed at rupees 6618 only per month with effect from 31/10/2010. Inclusive of taxes also. The rent has been refixed as per Assam Urban Areas Rent Control Act 1972. The calculation was given in page 23 and after 6618 it was never reassessed. For that only on 8/5 there is an direction order passed in this writ petition to submit an application to the circle officer. And accordingly we have submitted the application, Lord. Paragraph 7 of that order itself says Mr. Henry Clarnet, Junior Government Advocate appearing for the respondent number 6 has submitted that on receipt of such an application from the petitioner, the respondent number 6 will make endeavor to provide the zonal valuation in respect of the subject plot as on
What is the procedure for fixation of the rent under the Act?
Lordship, that is Page 23, it is already there. The valuation of Assam type building, paragraph.
That is there, but according to you, subsequently, rent ought to have been increased.
For the zonal valuation of the land, according to the zonal valuation of the land.
This 6618,
Lordship.
page number 22.
Lordship.
They have calculated the rent at this rate, isn't it? 6618.
Yes.
So you are not you are agreed by this.
No, Lordship. 6618 up to 2015, Lordship.
Ah.
So accordingly, we have received the amount.
You have
After,
received.
yes, Lordship. After
Then
2015.
from 15 to 18.
19, Lordship. November
19.
19, they vacated. So at the same rate, they have paid the entire
So
amount.
what is the process for under the Act where the rent is not enhanced?
Lordship.
What is the process for enhancement? Who is to enhance?
Lordship, the department itself, the earlier it was enhanced by executive engineer, Lord.
What about section 4?
Procedure for determination of fair rent. In fact, there is no dispute. They are admitting and they have already initiated proceeding. Lord.
According to you, it ought to have been increased.
Yes, Lordship.
Not done.
And they have initiated already, Lordship. In affidavit, it is mentioned that, Lordship.
Where?
Affidavit in opposition by respondent number 5.
Yeah. Page number.
Annexure 3,
Paragraph.
page 41.
Paragraph
Annexure itself, Lordship.
41.
Yes, page 41. Reassessment of hired building occupied by assistant executive engineer, Lordship.
Hmm.
With reference to the above, I have the honor to state that the above mentioned building, which was occupied by the assistant executive engineer PWD Karimganj, has been used up to 39/11/2019.
So not done.
It was not in dispute that they have not vacated.
But it was not done.
They have initiated. In this connection, it may be stated that the rent for the building was fixed at rupees 6618 per month with effect from 31/10/2010 by your letter under reference. I therefore request you to refix the building rent with effect from 31/10/2015.
Ayub?
Lordship, may I kindly see page 28, the earlier order, Lordship, passed by your Lordship.
Yes.
Dear Lordship, may I kindly see paragraph 2. This writ petition has been filed by the petitioner seeking directions from the court to the PWD department for release of rent in respect of a building owned by the petitioner which was taken up on rent by the PWD department as the office of the assistant executive engineer, the learned counsel. So this was the first given, rent was not paid. And secondly,
Rent was not?
Not paid.
Not paid. So that was a grievance, Lordship. But during the pendency, during the hearing, Lordship, another objection was raised. Lordship will find at page 30.
Yes.
Page 30, paragraph 7. Lordship may kindly see the order. Upon taking into consideration the submissions made by the council, this writ petition is disposed of with direction to the respondent's PWD department to expedite the release of rental amount due to the petitioner in respect. In fact, this rent was already paid to the petitioner as is reflected in my affidavit, Lordship. Second direction was there, Lordship. Lordship may kindly see last 5 lines, Lordship. The circle officer Karimganj is also directed to furnish the revised rent applicable under the Assam Urban Rent Control Act 1972 in respect of the premises belonging to the petitioner to the Department of the Public Works Department within 30 days from the date of this order. Upon receipt of such figures from the circle office, the PWD department will further process the claim of the petitioner in respect of the revised rent if found admissible. So, in terms of this order, Lordship, circle officer was to revise fix the revised rent. Lord.
Who's for the circle officer?
That instruction will require, Lordship. If they have fixed, Lordship, and if it is found admissible, then definitely will process, Lord.
You are supposed to give the fair rent in enhancement of the fair rent.
Enhancement.
Please come to, do you have the affidavit with you? Filed by the department.
PWD, yes.
Come to para 4.
Payment of made.
Para 4, you'll find the amount of 6618.
For the
period
period
1/4/2015 has been made. According to the petitioner, the 6618 was required to be enhanced.
Kindly see page 39 and 40 of that affidavit. The rate of 6618 is paid up to 2019.
18.
Two pages are there, 39 and 40.
The bill given by the house owner, Lordship. As it was not reassessed, so on earlier rate, we have submitted the bill.
So whatever they have submitted, we have paid.
That was already given. In the earlier round of litigation, there was a specific year for the enhanced.
Into enhancement. $15.5 make it answer.
8.5.
Your prayer is to direct them to calculate the due rent, etc., etc. There is a procedure there under section 3.
No, Lordship, in the earlier round of litigation.
Earlier round, we directed if it is not
Yes.
complied with,
Then
what step to take. But
Lordship, without going for Lordship contempt petition, we have prepared this writ
that is
petition
your
as
call. We are not
Lordship.
here to give you legal
For that
advice.
only, Lordship, on 8.5, there is a direction given to file and to submit a representation. Accordingly, we have submitted, Lordship, and thereafter, an status report was directed to be obtained by the council.
So what orders can we grant here? We can't give you any orders.
Lordship can call for a status report,
Why
whether
should we
circle
call
of
for it? When the procedure is prescribed, you go and approach the proper authorities. Or if this is not the fair rent.
No, they have initiated, only there is a delay, Lord.
So if there is a delay, what can we do?
There is no dispute.
We have
If there
already issued a direction.
already there is a,
Then why should we issue another direction?
on 8.5, there is a direction in this writ petition, Lordship, to file the, to submit an representation. Accordingly, we have submitted.
Okay.
And there is another direction to the standing council to bring instruction what measures they have taken after our
No,
representation.
don't reduce a writ proceeding to that of the proceeding before any executive authority.
Lordship.
This is you're
There
coming
is
before
no
a writ
dispute,
court.
so we are not going for Lordship money suit and all.
You are not going, that is your call.
Yes, because there is no dispute, Lordship. They are agreeing and they admitted that it was already processed.
Madam, we can't give you legal advice. You know exactly what to do. And instead you are coming here for a second order.
Lordship, at least, Lordship, what happened after my submission of my representation, that report they may obtain, Lordship.
That will direct them to dispose and give it to you. Order. Why should the writ petition be kept pending for that?
Unless,
in fact, we are finding it difficult not to dismiss it. What is your prayer? Kindly see
Already
your prayer.
there was a direction in the earlier round of
Please
litigation.
see your prayer in the writ petition. What is the prayer here? You are seeking a mandamus and direction, directing the respondent authorities to calculate the due rent as per provision of rent control. What is the provision here?
That was doing in the earlier in years. They have calculated as per Assam Land Revenue
All
Regulation.
right, heard MS R. Chaudhary, learned counsel for the petitioner, Mr. H. Purwa, learned counsel, standing counsel, government advocate, appearing for
1 to 5 I have written.
1 to 5.
And for 6.
Nayak for respondent number
6.
6.
6.
Huh?
1 to 5 I have
1 to 5. And Mr. Purwa for 6. This writ petition is a
At least the status
subsequent
report,
writ
Lordship.
petition filed by the petitioner, praying for a direction to the respondents to calculate the fair rent payable to the petitioner for the premises which were under the occupation of the PWD department, and for which the rent for the period under occupation of the department has been paid, but the same was calculated, same was not on the basis of the fair rent required to be calculated for the period concerned. So it is as per the documents enclosed to the writ petition, counsel for the petitioner submits that for the period prior to 1/4/2005, the fair rent has been calculated and paid to the petitioner. However, for the period 1/4/2015 to 31/3/2018, the fair rent was calculated at the earlier rate, not at the enhanced rate, and the amount of rupees 2,38,248 has already been released to the petitioner. Petitioner's grievance is that the balance amount payable to the petitioner, had the fair rent been calculated at the enhanced rate for the period 1/4/2018 to 31/11/2019, has not been paid. So it is submitted that there was a step taken by the department for recalculation. However, no information is forthcoming from the department. So petitioner has referred to an earlier order passed by this court in a writ petition filed by the petitioner, where is that order?
Page
27.
Whereby order dated 22/6/2022, passed in
Page
WPC 1385 of 2020. The PWD department was directed to expedite the release of rental amount due to the petitioner in respect of the premises occupied on rent belonging to the petitioner. The further direction was to the Circle Officer Karimganj to furnish the revised rent applicable under the Assam Urban Rent Control Act 1972 in respect of the premises belonging to the petitioner, which were taken on rent by the department, and furnish the same to the PWD department. So it is submitted that notwithstanding this direction, the state authorities have not, the Circle Officer Karimganj has not furnished the revised rent. As per order dated 8/5/2024 passed in this writ petition, petitioner was permitted to approach the respondent number 6, namely Circle Officer, by filing a necessary application for fixation of the zonal valuation of the said plot of land. Stop. It is submitted that pursuant to the liberty granted by this court on 8/5/2024, petitioner has approached the Circle Officer. However, the application has remained pending. No order has been passed. Being aggrieved, the present writ petition has been filed, seeking a direction to the respondent to calculate the rent due to the petitioner as per provisions of Assam Rent Control Act 1970. The respondent PWD has filed their affidavit showing the particulars of the amount paid. According to the department, the entire amount has been paid, including the amount for the period 1/4/2015 to 31/3/2018 at the rate of rupees 6,618 per month. Stop. Learned counsel appearing for the PWD submits that once the parent, as directed by this court by the earlier order dated so and so, passed in the earlier writ petition number WPC so and so, is furnished, then the department can take steps to uh, for release of the balance amount if found payable. So, this court, by earlier order dated 22/6/2022, passed in WPC 1385 of 2020, has directed the PWD to release the rent payable to the petitioner, and also directed the circle officer to intimate the fair rate for the concerned period, and the writ petition was disposed of. So, it is also necessary to refer to the provisions of the Assam Urban Areas Rent Control Act 1972. In so far as the procedure for determination of fair rent is concerned, the Act prescribes for a detailed procedure under Section 4, where it is provided that in case of any dispute regarding the rent payable in respect of any house, it shall be determined by the court. So, under Section 2A of the said Act, court is defined as a court of ordinary civil jurisdiction in the area in which a house is situated, which would be competent to pass a decree for eviction of a tenant from that house. So, having noticed the provisions of the Assam Urban Areas Rent Control Act 1972, it's clear that the statute lays down a clear and definite procedure for fixing the rent due and for recovery of the same, and steps and procedure that may be adopted in the event the tenant fails to pay the rent. This court has already directed by the earlier order dated while going of the writ petition to the circle officer by the parent, and further, in terms of the liberty granted by this court by the order dated 8/5/2024, passed with the present petition, petitioner has also filed. Petitioner also claims to have filed representation before this concerned circle officer. This court does not consider it necessary to enter into the dispute of deciding whether a specific order be issued to the respondent via the parent, as the Assam Urban Areas Rent Control Act 1970 clearly lays down the procedure prescribed. So, if the petitioner is agreed, then the petitioner may approach the competent authority under the state act. Therefore, the court is not inclined to pass any direction to the respondent to calculate and or release any rent However, considering that by this court by Article number dated 8/5/2024 permitted the petitioner to file the representation to the circle officer at which the petitioner claims to have filed, the circle officer is directed to dispose of the same representation within a period of 2 days. 15 days from the date of receipt of a certified copy of the order to be furnished by the petitioner. Any order that may be passed, copy thereof shall be furnished on the record. Save and accept as directed above. No further orders are no further order can be issued. That disposed of in terms of the
I'm deeply obliged.
Yeah.
Also, can you look into the order at 1970 or 2024, madam? As for that order, madam, the response number 5 and 6 is directed to submit. Accordingly, they file an affidavit saying that they will furnish the information within a period of 7 days. Now,
then
we file and reply to that affidavit. LSS can reply, madam. Case 56 it starts, madam.
May I please one? May I please? In this case, the reply has been filed. I checked the record, but my name is addressed to me, but no copy is up to me.
All right.
So therefore, at this stage, I am unable to reply.
A reply filed by petitioner,
Petitioner.
which is on 10th of September.
Madam.
What do you want to say?
Here they are supposed to file within 25/7/2024. They submitted certain information. Paragraph 4 onwards, madam. The department explains that although due to the strict direction of the honorable court, the respondent of 5 and 6 ZDA, while letter dated so and so, provided some information but still avoided to provide a main document which have been sought for under the RTA application filed by petitioner on 9/8/2025. The response as a Development Authority provide the following information. This is I have mentioned. One, furnish the bank statement of one bank with from so and so to so and so in place of Xerox copy of the cash book with from so and so. They failed to provide the information. 225 malot serial number. That is the document malot that annexa actually annexed 2 to that opinion of position at page 72. The minutes of the board meeting that those documents are provided up to 5. But however, the finalist did serial number 6 done. However, the finalist advocate did not. What they try to say, I could not understand. The information they could not furnish in the particular version. Could log into the next page 73. The information their answer is the Kora Hoisil. কিন্তু উক্ত সময়ত পেনেলিষ্ট এডভোকেটকে কোনো তথ্য নিদিয়াৰ সংক্ৰান্তত প্ৰস্তুত কৰিবলৈ তথ্যসমূহ কাৰ্যালয়ত মানে দিছ ইজ দিয়াৰ ডকুমেণ্ট মানে they denying the document in the name of some panelist advocate. You know, that person who holding the post of the ZDA chairman, he has already retired on 15/10/2024. He tried to defy the higher authority order as well as the court direction. So
Your affidavit, you have not received a copy of the affidavit.
No.
If you not served him a copy.
He served, I don't know why he is not.
No.
I can provide him, but
the signature was done by the office of government, not by me.
No. Whose government office? Government?
They have taken.
Okay.
They have served
serve him a copy?
to the government. Not
Serve
to
him
me.
a copy.
Malad, I'll serve him, Malad. What is it? Malad, next week any day, Malad.
Any day. Choose your day.
Malad, can it be on Malad?
11?
prior to that, can it be possible on 6th, there is a Friday, or 5th, there is a Thursday?
No, Lordship, because if there's something against me, so I maybe file a reply against the reply.
Oh, you have not even received. How do you know there's something or nothing?
Because they have said there's a,
You go first, go
copies
through
not-
that.
Definitely.
We can have it on 4th.
Mala.
4th?
Mala.
List on 4th. As it is submitted that the council appearing for Jorhat Development.
Yes, Lordship, 5 and 6.
Mr. Chetri submits that the affidavit in reply filed with the petitioner has not been served on you. Counsel for the petitioner will serve a copy. The said affidavit during the course of the day. Let the matter be listed. As agreed to, let the matter be listed on 4th. December. Mr. Teka appears for
Question number 4.
4.
RTA Commission.
RTA.
Like.
May please, Your Lordship. Lordship, I need 2 weeks more time to file my reply.
Right. Counsel for petitioner prays for 2 weeks further time. File reply. Mr. Teka appears for the respondent. 5. Mr. T. Bordoloi for the petition.
Obliged, Your Lordship.
Lordship, in this matter, we have filed an affidavit in reply against the affidavit in opposition filed by the respondent number 1 and 2, but it has not been tagged with the records, Lordship. So it may be fixed in the
So the petitioner submits that affidavit in reply filed by the petitioner.
dated
Filed by
11/11/20
the petitioner on
11/11/24.
11/11/24. However, the same is not available in the case report. Registry to trace out the affidavit stated to have been filed and connect it to the case report and list the matter in the month of January.
No, Lordship, in the next week, Lordship, because the petitioners are suffering financially.
Preparing for the respondent number 1 and 2. My lord, we need to respond on the affidavit that has been filed by them. Let it tell to the record.
You have received copies.
My lord, I have.
Then, how much time you require?
2 weeks time may be allowed for filing our counter.
2 weeks time.
Lordship, a date may be fixed.
My lord,
Let it come in January first week.
Yes.
Lordship, actually, the petitioners are suffering financially because the bank has frozen the amount of rent that they have received. They can't access the amount and
Or at least on 11 December. We'll see. You see what instructions you can get. We'll see what orders we can pass.
my lord, we have filed our affidavit.
That's right. You said you wanted some instructions on the reply affidavit.
Yes.
So get it by 11. 11 December.
All right. All right.
It is that the account to bank accounts of the petitioner has been freezed, and subsequently on the direction of the IU, that account has been defrozen, and that is with regard to SBI. And subsequently, one account is left with the Punjab National Bank, and that has also been we have written to the authority, the bank authority, and then that has also been unfixed.
All released.
Yes, sir.
Okay, copy of this order may be furnished to me.
No, that will be a part of record.
Heard counsel for the parties. In terms of the earlier orders passed, the learned government advocate has placed before this court copy of the instructions received from the office of the Superintendent of Police, Vishwanath District, Vishwanath Charity. In terms of the said instructions placed, learned government advocate submits that petitioner's accounts, current account number so and so and savings account number so and so maintained in the SBI, Vishwanath Charity, were unfrozen on 28th of December 2023. Subsequently, the account number so and so maintained at the Punjab National Bank. Which branch? Vishwanath Charity.
Vishwanath Charity.
Has also been unfreezed by the bank. Stop. In that view of the matter, the grievance of the petitioner has been redressed by the respondent. A copy of this instruction is placed before the court is kept on record. Writ petition accordingly stands closed as not pressed in view of the instructions placed before the court.
Date of deposing may be recorded of the Punjab National Bank.
Date of
Defreezing, Lordship, that is on 25th 11.
it was Punjab National Bank account has been unfreezed on 25/11. 2020.
Please, your lordship. The petitioner number 1 to 60 are purchasers of Bharat Stage 4 two-wheelers, and petitioner number 61 is the dealer of the Bharat Stage 4 two-wheeler. We are seeking a direction here to get the two-wheelers registered. And
Why is the direction required? Why is it not registered?
Lordship, there was a judgment of the Honorable Supreme Court in MC Mehta's case that following which there was a direction of the Honorable Supreme Court in MC Mehta's case that's reported in 2017 7 SCC 243. It was in para 50 of that judgment. It said that it appears to us that if someone was to make a bona fide purchase of Bharat Stage 3 compliant vehicles on or immediately before 31/3/2017, it might not be possible for that individual to have the vehicles registered before the cutoff date. Therefore, we felt it reasonable to permit the registration of Bharat Stage 3 compliant vehicles purchased on proof on or before 31/3/2017 from 1/4/17 and have ordered accordingly. But my lord, thereafter, because of the COVID pandemic, most of the vehicles could not be registered. After the COVID pandemic came, during that time frame, the vehicles could not be registered. And then another judgment of the three-judge bench reported in 2019-17 SCC 490. Therein, that cutoff date was put in by the Honorable Supreme Court. It was said that every vehicle sold after the cutoff date of 1/4/2020 is bound to cause more pollution, and therefore the manufacturers, in our considered view, cannot be permitted to sell any non-Bharat Stage 6 compliant vehicles on or after 1/4/2020. So, my lord, and this
That all purchased before.
Yes.
But registration could not be done.
Could not be done. And after that, the pandemic.
But now, if the registration is there, you start running your vehicle, cause more pollution.
My lord, the Honorable Supreme Court and some of the purchasers earlier round of litigation, they were parties, my lord, and which culminated in the order passed by this Honorable Court, Honorable Justice Medhi's order. In that lordship, a few petitioners had come, 10 of them, 19/7/22. It's annexed in page 39 to 41. So the direction that was given by the Honorable Supreme Court in Devobrot Borua and 9 others who were before the Honorable Supreme Court by filing an SLP was to find out whether the vehicles were genuine or not. So that process was also gone through. And this time also my learned friend has filed an affidavit saying that all the 60 petitioners, their vehicles are genuine. That
What is the meaning
exercise
of
was done.
vehicle genuine means?
Versus before 31/3/2020.
So you want an order now for registration?
Of this 60 two-wheeler. The affidavit at page 867 in fact.
Where are the orders of the Supreme Court?
Our 515, Lordship, our particular matter concern was Debobrat Borua. That's in page 534, Your Lordship. Will find IA number 1110988, page 534. Application for direction on by order, Debobrat Borua and others. Learned senior counsel appearing for the applicant pray for withdrawal of this interlocutory application for direction with liberty to file a fresh application before the Guwahati High Court. Prayer is allowed. Accordingly, the present interlocutory application is dismissed as withdrawn with liberty aforesaid. However, the High Court may consider the genuineness of purchase.
Where is the original order restraining the registration of vehicle
Okay.
after the cut-off date?
Yes. Okay. And then we are back on it. Ever. Wait. 496, my lord, I can have a look.
Lordship, that
Page is 502.
Lordship. There is an order of the Honorable Supreme Court, 13/8/2020. There at page 512.
No, this
The
is
deadline, lordship, will get in page 500, my lord. The third paragraph. Page 500. With respect to unsold vehicles, as the manufacturer should have been ready because of deadline set for BS6 content vehicle, there is no justification to extend the time which was fixed long time ago. It is not something new which has occurred. It would be further injurious and further burden on human health caused by pollution of BS4 vehicles. When BS6 vehicles are supposed to be produced by the manufacturer well in advance, considering the deadline of 31st of March 2020. It is stated that there are 7 lakh two-wheelers which are unsold throughout India with different dealers. Similarly, passengers vehicles are 15,000, commercial vehicles 12,000, Delhi and NCR region. We are not allowing sale and registration of these kinds of vehicles anymore. However, in the remaining part of the country, due to situations which has arisen due to lockdown, it is observed that not beyond 10% of vehicles, except in dealers in Delhi and NCR region, are permitted to be sold in the aforesaid number of vehicles and our case deadline was 31st/3/2020. Earlier on the litigation lawsuit, Honorable Court has got an order. Lawsuit will get it order in page 41. That 41. Lawsuit may kindly have a look for paragraph 3 onwards. 42, page 42.
Paragraph 5.
3 onwards, the fact is there in 3.
So, as per page 500,
Lordship.
except for Delhi and NCR,
Yes, my lord.
rest of the dealers are permitted to sell subject to 10%. So, where is that exercise done by the authority to show that these vehicles are within that 10% quota?
That they have to provide us the documents because as per the earlier order,
They
my lord.
provide. You are to go for registration.
Lordship.
They are asking for registration, which is to be undertaken by you.
Lord.
So while exercising this registration, you have to first not only registration, in fact, perhaps subject to correction. We can't pass any orders for registration if we find that they are beyond 10%. A very strict direction. Page 500, last paragraph.
My lord.
We are concerned with Bharat Stage 4 vehicles, Lordship, and there is an order of the Honorable Supreme Court at page 512. Start here, Lordship. At page 513, if I can take your Lordship too.
No, this is okay. This is the sequel of the earlier order.
Yes, Lordship.
This has merely extended the deadline.
Yes, Lord.
But the precondition has not been altered, which is 10% of the unsold vehicle. Whether your vehicles are within that 10% or not.
These were sold prior to lockdown, and in fact, in Assam, when that no registration was without registration, the vehicle owners were provided the vehicle, so they are their vehicles are still with them. The purchasers, they have it with them. The only impediment that was there was.
Oh, I understand.
Yes, Lord.
How do you decide on this direction at page 100, page 500?
Yes, Lord.
Last paragraph. It says yours are what, two-wheelers?
Yes, Lord.
So
Two-wheelers.
7 lakh two-wheelers. It doesn't describe which dealer, which state, how many vehicles are there. It's not here. But in so far as two-wheelers, only 10%, that is 70,000 across the country.
Lordship. Lordship, it is unsold, but their vehicles are already sold.
Sold, Lord.
These are unsold. Observation is page 500. It's regarding unsold.
So you mean to say prior to this order, vehicle has been sold?
Yes, Lord. Okay, Lordship. 513 matter. Page number 513. Is the last page. Observation on the second.
Yes.
Last page. 513. There are sales stated to be a large number of sales which have been made and uploaded on the e-Vahan portal. Even temporary registration were made. Their registration during the lockdown period could not be made. Hence, the allowed registration of such vehicles only which could not be registered during lockdown in the month of March 2020 and for no other region. However, the position of Delhi and NCR is different. So, verify. We verify our orders dated 27 effective.
Where are the vehicles? When were they purchased? Which order?
The purchase vouchers are annexed, Lord. In fact, I had also filed an additional affidavit. Bringing on record the list of purchaser, their engine number and other purchase details.
Page number?
Page 556 to onward is the list.
556.
Yes, sir. to 559. All 60 passengers are there. Vehicle owners who are before your lord.
No, but where are the documents? You have to, are the documents available? Sale certificate. This is a statement you have made.
Yes, Lordship.
Right. All these are petitioners before this court.
Yes, Lord.
All of them.
Yes, all 60 of them. The application form for registration has also been annexed to the petition. That's Annexure P4, Lordship.
And
Lordship, and police case is also registered because in paragraph 13 of the
where
petition,
is that modification order? That is page 530.
honorable apex court order here.
No, that there were some IAs which are reflected in the Supreme Court order. You just pointed out. Fine.
Five 534, Lordship. For direction on by order Debobrat Barua and others. They were there before this honorable court in the earlier round of litigation. Last para, Lordship. However, the High Court may consider the genuineness of the purchase.
Now this is only with regard to those persons
Who
or
were
is it
there
open to
before
all?
the apex court.
Huh?
Similar directions are required by this petitioner.
No, no, what we are asking you,
Yes, Lordship.
this page number 534 is directions which are issued in favor of Debobrat Barua.
Yes, Lord.
Is it a direction in respect of all similar situated persons or it's
Lordship,
only in respect of Debobrat Barua?
Debobrat Barua and 9 others in their individual capacity were before the Honorable Apex Court. And there was another petitioner, namely the petitioner number 10, who is the company, the dealer, in their representative capacity, that JB Energy Private Limited, who is also before your Lordship's court.
No, you are saying that pursuant to the order, notification order or order passed in the IA at page 534,
yes, Lord,
these people appeared before this court and an order was passed.
in
Now-
their individual capacity, and the petitioner number 61 today, she was also there in the previous round of litigation as
Who is
petitioner.
61? Owner,
That JB Energy Private Limited, the dealer.
dealer.
Yes, Lord.
That's okay. But the order passed by the High Court is pursuant to the directions issued by the Supreme Court in this IA.
Yes, Lord. No,
Now-
after that,
Ah.
we had come filing a writ petition pursuant to this direction. Then only 9 of them had come before this honorable court. Today, 60 of them are here.
What I'm saying is, there is an order of the court putting an embargo on the sale or beyond a particular
Bharat
date.
stage 4
beyond a
Right.
particular cutoff
Yes.
date. Then it was modified to permit those sales which were made earlier to the cutoff date but could not be registered.
Yes, Lord.
You fall into that category.
We could not be registered then. Yes.
Whatever reason, but it was before the cutoff date. The sale was complete.
Sale was complete before the cutoff date.
Right.
Before the lockdown was imposed.
Right. But you did not approach the apex court. You were not parties before the apex.
We were not there, but the dealer, who is petitioner number 61, she was there in her representative capacity because she is the owner of the company.
She was there as an applicant.
Yes, Lord. Together with Debabrot Guru.
But whether she was in representative capacity for all of you or only for the home, where do you find all these material? See, there is a liberty granted by the apex court, pursuant to which orders are passed by the court. Liberty is granted in respect of parties in the IA. From this order, it is not discernible whether the party in the representative capacity represents all the parties, including you, who are not individually before the apex court. You have to state all this or produce a copy of those documents to before the court to say that under these circumstances the court had permitted.
I had otherwise annexed the sale certificate and
I agree everything.
yes, Lord.
The order passed in this 502 page of
Yes,
this
Lord.
order.
Yes,
There is a blanket order saying that beyond the cutoff date, no sale,
yes, Lord. So now,
no registration.
yes,
Then it got modified that somebody who had purchased it could not get it registered, so therefore you permit them to register. Right. While doing so, somebody approached them and filed IS,
Lord.
perhaps seeking the same relief for a direction with liberty to file fresh application. So pursuant to that application was filed.
Lordship, and there was an order from this honorable court also.
No, I know, but that is
17/5/24 to verify the genuineness of this 60 petitioner.
that is pursuant to the liberty granted by the apex court in respect of those petitioners.
Lordship, that is there, but in this round of litigation also, there was an order by this honorable court dated 17/5/24 in which similar direction was given to verify the genuineness of the 60 number of vehicles. My learned friend has put it in her affidavit.
All right.
Page 864 to onward.
We are asking you from the technical point of view. There is a liberty granted by the apex. Whether that liberty applies to you or not. You say it is applicable.
Because
but we are passing the order, we have to satisfy whether it is applicable. Let us say, for instance, the dealer appeared in a representative capacity.
Yes, Lord.
And the dealer comes before this court seeking orders, or maybe is the dealer a part of this petition?
Yes, yes.
As a
61.
petitioner?
61. Petitioner number 61.
Okay.
And there is a statement made, Lordship, at page 18 in the pleading, para 6.
No, before the Supreme Court, you had gone and got the liberty. Have you made a statement here? Okay, heard 32, page 28.
Yes.
You made a statement.
Lordship, another point that I want to point out, in page 513, this applicable says on observe, my lordship, I have to one line. Page 513.
Yes.
There are still specifically large number of sales which have been made and uploaded on the e-commerce portal. Even temporary registration were made. The registration during the lockdown period could not be made. Hence, we allow registration of such vehicles only which could not be registered during lockdown in the month of March 2020 and for no other reason. Then Lordship may kindly have a look page 20, paragraph 13. Why they have did not register the vehicles. Page 20 of registration, paragraph 13. That the remaining 670 vehicles, however, could not be registered as mentioned herein above.
Page number?
20, madam, 20. Paragraph 13.
Yes.
That the remaining 678 vehicles, however, could not be registered as mentioned herein above, despite the registration fee being deposited. Two employees of the petitioner number 61 company, it is Rabul Naidu, who was entrusted with the handling of the registration process, and Gautam Borwa, who was the sales manager, did not get the vehicle registered and had both of the registration fee. But the only reason the Honorable Architect has granted, if anyone register the vehicle due to lockdown, only that has been permitted to register. Page 513. That they have to clarify.
Registration during the lockdown could not be made.
Yeah, but here the case is different.
Here
They're
it
not
is
saying
because of the dealer.
no, the someone has
They
The two
deposited the
employees
money.
bungled up the money.
two
They
employees,
deposited the money. Somebody ran away. Not their fault,
but not the purchaser's fault.
right?
But
But-
the honorable court has observed if someone did not register the vehicle due to lockdown, then only it is allowing for the registration of the vehicle, the PS4 vehicle. But their reason is quite different, my lord. They are saying that their employee has. It's only lordship observation, my lord, up to my lord. In the earlier round of repetition, they have stated one case is registered against the two persons.
Registration of vehicles only which could not be registered during lockdown, not due to lockdown. Okay, heard counsel for the commissioner. Let's see. Transport department. It's 5. by 61 number of petitioners. Petitioners 1 to 60 are they are the owners, purchasers of two-wheelers from the petitioner number 61, who is the authorized dealer. Because of certain, because of by reason of mischief played by two employees of petitioner number 1 who did not deposit the amount collected from petitioner 160 for registration, and eventually they disappeared with the amount without the say the registration authority. And thereafter, COVID-19 pandemic situation set in coma. Although petitioners want yet collected money, employees of petitioner number 1 vehicles, wheelers were purchased by the petitioner 1 could not be registered. Pursuant to the COVID pandemic 19 situation returning to normal in a what is this? This is a PI law in a proceeding for the apex court being petitioner number 1309 of 1985. The apex court I ordered it 27/3/2020. So what was the earlier order? First order? Petition the apex court by order dated 27/3/2020.
First order was lordship 24/10/2018,
Where is that?
496. Four 97 is the direction.
By order dated 24/10/2018. In terms of passed an order that Bharat State Roman 4 vehicles shall passed an order that no motor vehicle conforming to the emission standard Bharat State Roman 4 shall be sold or registered in the entire country with effect from 1/4/2020. In subsequently, in the IAs which are filed in the State Commission by order dated 27/3/2020, the court permitted sale of Bharat Stage 4 vehicles, permitted sale of Bharat Stage 4 vehicles up to 10% of the unsold vehicles across the country except Delhi and NCR. This order again came to be modified, came to be altered by order dated
2/11.
13/8.
2/11/2020.
No, no, page number 513.
Order is-
This is order dated 13/8.
Yes.
13/8/2020. Court directed that registration of vehicles which were their sales were uploaded in the
E-Vahan.
E-Vahan.
Yes, sir.
It was uploaded. That the vehicles whose sales were made and uploaded on date of purchase of insurance, page number of the sale certificate, etc. are enclosed to the affidavit. Stop. The relevant paragraphs of the affidavit are extracted below paragraph 3 and 4. So, better. Having considered the submissions made before this court and also upon careful perusal of the order passed by the apex court, and also the affidavit filed by the transport department certifying that the petitioners 1 to 60 are genuine purchasers of their vehicles. The writ petition stands disposed of with a direction to the respondent number.
Lordship, the petitioner have to deposit their fees. President Pete, he had to deposit. That's number 5, my lord.
5, namely
DTO Jorhat.
DTO Jorhat, to complete the process of registration of the individual vehicles of the writ petitioner 160, subject to the deposit of necessary fee and charges as required at the so, while proceeding with the the steps taken by the respondent is so directed view of the government, the affidavit is filed by the department that the vehicle purchases were genuine purchases made before 31/03/2020. In terms of the above direction, it stands allowed in the entire exercise be completed in specific time.
After reporting the report.
After the charges are reported.
Here I am paying for 1, 3, and 5 only. There are others.
Who are the others?
And for 1, 2, and 5 others, the government is there for SP, Superintendent Police, and the insurance company is also.
Whoever
Plus, I am
who are there
allotment
representing them.
5 only.
1, 2, and 5.
I'm so disturbed. Grateful. Much of that.
We'll take it up on Friday.
Friday, well, can it be on 3rd month?
3rd. Okay. 3rd. Let this matter be listed on 3rd. As requested. The council. Mr. Saiwala, not object to the prayer made. It's on 3rd.
Can I pray that matter be taken at 2, my lord?